All right, back on the record. The record should reflect the presence of Mr. Wong, Mr. Coughlin, and Laura Peters on the stand. When we finished at noon, Mr. Coughlin was in the middle of his cross-examination. Mr. Coughlin, go ahead.
Yes, sir. Clerk Peters, do you recall submitting some police reports to the Reno Police Department?
Yes.
Do you recall what you wrote in those reports?
Not verbatim, no.
Or just generally?
I reported each of the incidents, pretty much as we discussed earlier. The delivery of Exhibit C, and then in a separate report, the delivery of the fax motion that I stopped transmission on.
And why did you stop transmission on that?
Because it was over 200 pages and our fax machine won't handle that.
How so?
Well, it malfunctions at a certain point.
How does that manifest itself?
I don't know, I don't work on fax machines, it just,
Well, then how do you
the
know?
paper
it malfunctions?
jams and
Which is it? You don't know, or the paper jams?
the paper jams, I don't know why it jams.
Okay.
It's a fax machine.
Is it maybe a case where once a certain amount of paper stacks up, that paper needs to be removed?
No.
Make room for new paper? That's not why?
It misspeaks.
It misspeeds? What model of fax machine do you have?
I don't know.
How many fax machines do you have?
We have one.
Can you describe it?
We just purchased a new one. I feel when I could really tell you, we don't work on them.
Okay, could you describe the one that the State Bar hadn't used during the relevant time in question?
What date would that be, Mr. Coughlin?
Yes, sir. I believe the fax at issue in Exhibit F would be on January 17th, 2013.
Okay, that's a question that calls for a simple answer. You can answer it or you can't.
It was an HP all-in-one fax machine. That's all I know.
Okay. How big was it?
That's irrelevant, Mr. Coughlin. I mean, look, I tell you, we're going to get right back to where we were. Ms. Peters has come in here and testified on a very limited amount of questions from Mr. Wong that she received certain items delivered to the office and faxed. And your cross-examination needs to be limited to that. We've given you a lot of leeway, but you start going out on tangents that are irrelevant, and we're not going to spend the afternoon on irrelevant tangents like how big is the fax machine. It's irrelevant to this case. Next question.
Your Honor, if I may just be heard on that briefly?
Well, go ahead, but I don't want to sit here and have an argument with my rulings. We'll spend all day, and then you go on for 2 or 3 or 4 or 5 minutes.
No, sir, I don't want to argue with you.
Then ask the next question.
If I could just quickly...
Well, go make it quick and make it clear.
Initially...
You have a real problem as you sit here outlining anything you want to say. And so everybody gets frustrated, and so do you. If you have something to say, make it short, make it to the point, and make it relevant. And then that makes this your cross-examination meaningful instead of convoluted and hard to follow. But what do you want to say?
Yes, sir. I'm just confused. To one extent, you referred to what was brought up on direct and limiting there too, and then it seemed that you made an indication that regardless of whether it's on direct or in my case in chief, it would be irrelevant. And I would just submit that I do think reasonableness is an issue here in terms of what manner of contacting or what manner of submitting filings is involved, and any curtailing of one's constitutionally protected right to submit filings to a court.
Your constitutional rights aren't unlimited. You seem to think they're unlimited, and we're not talking about that. The size of the fax machine is irrelevant to the, anything that has to do with this case. So I'll ask your next question. Go ahead.
With respect to the January 3rd, 2013 incident, what did you write in your police report?
Roughly, I described the incident, but I can't tell you verbatim what I wrote.
Okay, would
I
you,
wrote that a man approached the door as we were getting ready to leave. I told him I wouldn't file in anything, but he was welcome to drop through the mail drop. He did so, and he left, and so did we.
so you did indicate to him that he was welcome to drop the filing in through the mail drop?
Yes.
And that was, you indicated earlier that you recognized the materials in the man's hands to be filings from the defendant, Coughlin, given some unique characteristics of such filings?
True, yes.
So it was after that recognition that you indicated an assent to the man filing such items by dropping them through the mail slot?
That was the only way they were going to get delivered. I wasn't going to fax them or file them in
Did you
after
indicate?
hours.
So after making that assent to receiving a filing from defendant Coughlin via a means which I believe you testified to earlier as being violative of the protection order, although I don't want to get into your...
Hey, look, the question now gets to be narrative. You start to talk and it starts to get to be rambling. But just ask a simple question for Ms. Peters and you do fine when you do that.
Yes, sir. Did you tell the man who submitted the filing that he wasn't allowed to do that?
No,
You made
I
no...
just said it was after hours, which it was.
Okay, but you didn't make any indication to the effect that you're clearly here submitting something for the Coughlin who's not allowed to
No.
so do so in this manner? Okay. Then why did you make a police report about the incident?
Because we had, by that time, an extended order which said that we didn't have to accept filings from you other than by U.S. mail.
By that time, January 3rd,
Yes.
even though the extension
Well,
period...
the extension order was the next day, ironically enough.
So when you say by that time, isn't it beyond irony? Isn't it just incorrect?
I did the police report on January 4th because the incident on January 3rd occurred when I was on my way home. I don't type on my way home.
Right, but the incident on January 3rd, isn't it true to say it occurred prior to the advent of the EPO?
Yes, but there was a temporary restraining order in place at that time.
But did you not just testify that the manner in which that filing was submitted was not violative, in your opinion, and not a basis for
I don't think I
filing
made
a police
that.
report?
No, I didn't make that conclusion.
What did you testify to? Just to
Your Honor, the objection, the record speaks for itself.
The record speaks for itself, Mr. Coughlin. And again, this witness cannot testify as to whether or not, in terms of, in her opinion, whether or not the conduct amounted to a violation of either the TPO or the EPO.
Yes, sir. Why did you file a police report with respect to something you indicated occurred on January 3rd?
The papers were delivered as I was leaving the office. The next opportunity I had to file a report was the next day I was at work.
Objection non-responsive, Your Honor.
Overruled. Next question.
Beyond the availability of time to file one, why did you file one?
The next day, January 4th, was the extension hearing for the TPO. I believe Mr. King notified Judge Pearson that you had tried to deliver a document. Judge Pearson actually suggested that I file a report on this violation
When did he do that?
on January 4th at the extension hearing.
So the transcript of that would reveal Judge Pearson suggesting to you to file a police report?
I don't know if that part of it was on the record, but
When did it occur? Within the context
on
of
that
the
same
hearing?
day, when we were waiting for the order to be signed.
Did it occur out in the hallway?
No,
Did it occur in the courtroom?
it occurred at his desk, bench.
And can you relay as closely as you remember what was communicated to you by Judge Pearson in that regard?
I'm going to not go into anything Judge Pearson has to say is now hearsay. We're not going to let either party, the city or you, Mr. Coughlin, or Mr. Wong, have hearsay evidence coming to court. So we're not going to have discussions about what Judge Pearson may or may not say. That's clearly hearsay.
And, Your Honor, may I
Go ahead.
offer a hearsay exception?
Yeah.
And that it's not offered to prove the truth of the matter asserted, and perhaps a business records exception in that audio jazz recordings are made of such hearings.
I'm not going to allow anything Judge Pearson said. It's not only is it, in my opinion, hearsay, even if the word of the being said, it's irrelevant. So we must ignore anything that Judge Pearson had to say.
Yes, sir.
In terms of his orders, speak for themselves.
Okay, and then may I have stricken her comment in that regard?
Okay, any comments that were made by Judge Pearson will be, while they're not stricken for the record, I will not consider those items in any way, in any manner related to this case. So to me, you're wrong as well.
Yes, sir. So, just briefly, the sum and substance of what you communicated in your police report and in, it was what, for the January 3rd incident, January 3rd, 2013?
Yes.
Is that a question? That's not a question.
I'm asking.
You're testifying, so why don't you ask her a question?
I'm asking Ms. Peters to briefly relate what it was you reported in your police report as to the 1/3/13 incident.
That's been asked and asked. She's indicated that twice now. I have, my notes are clear. Twice she's asked that question.
Yes, sir.
Twice. So I'm not going to go down that road a third time.
Yes, sir, Your Honor. I just felt she was somewhat non-responsive in that regard.
Well, no, very responsive. My notes are very clear. She's answered those questions several times.
Yes,
too.
Did you indicate in your police report that such submission of a filing by that man was a violation of the protection order?
I just reported what happened. I don't think I made any conclusion whatsoever.
Okay. And what? Okay. What about with respect to the January 17th reporting, or reporting connected to the January 17th to 2013 vaccine in Exhibit F?
Well, is there a question from Ms. Peters? I didn't hear a question.
What was her report? What did she indicate in her police report?
I described the receiving the fax and discontinuing the transmission at 25 pages or whatever it was.
Because
I
think
believe
we've
that's
gone
been
over
asked and
that.
answered at least 2 or 3 times based on the issues with the fax machine. We're not going to have that answered a third time.
Yes, sir.
That's what she's had to say.
had you indicated to the defendant that he was permitted to serve and or file documents in his disciplinary proceeding with the state bar by a facsimile?
I don't believe so.
Did you make any commentary in that regard or have any communications relative to that subject matter on or about September 11th, 2012, between any time on that day? Or thereabouts?
I
That
don't
approximate time.
recall.
You don't recall?
I don't recall.
Did you ever receive any faxes from the respondent, Coughlin, in that disciplinary proceeding now on appeal for the Nevada Supreme Court in 62337?
No,
You never received any faxes in that
not to my knowledge.
through the state bar?
We have an office down in Las Vegas as well. I think they received some.
You never once received any faxes from Zachary Coughlin?
At what time frame? Let's limit the time frame, Mr. Coughlin, to a window which we can understand where Ms. Peters can answer that question.
Between March 2012 and January, or let's say February 2013.
It's not my habit to file in anything that's faxed. Either it has to be received by mail or brought into the office in most circumstances. In your circumstance, I don't think you were allowed to come to the office, or we had asked you not to.
Objection non-responsive, Your Honor.
It's not responsive, the objection is sustained. I think the question was, did you receive, and maybe you can answer this, and maybe you can't, any faxes from March 20, 2012 to February 20, 2013 from Mr. Coughlin? If you did, you did. If you don't remember, you don't remember. If you didn't, you didn't.
I don't remember.
Okay, she doesn't remember.
Just to clarify, did the state bar receive any such faxes, particularly the northern office?
She just answered that question, and I'm not going to answer it again. I wrote down that she wasn't sure that the state bar in Las Vegas may have got a couple, so you just answered that. There's nothing to clarify.
Okay, I'm
It's
sorry.
very clear.
I thought she was answering just with respect to herself, not with respect to anybody at the state bar.
Okay, next question.
Did you, in your January 3rd, or your police report relative to the January 3rd, 2013 incident, write that, quote, yesterday evening, Mr. Coughlin parked his car at the end of the office complex's driveway and sent another individual to the state bar office to file a document? Did you write that?
Yes,
Did you earlier testify that you did not see Mr. Coughlin there that day?
I didn't see you personally. It was quite a distance. But given the subject matter, I could pretty much conclude it was from you.
Did you make any indication in your written police report that you were merely concluding or assuming that, rather than indicating that you saw as much?
I honestly don't remember what was in the report, detail by detail.
Did you indicate to the man, is it true to say you indicated to the man that he could submit for filing the document he proffered at that time via putting it through the mail slot?
I don't know that I had that much of a conversation with him. I just said, there's the mail slot. That's fine.
Did you give him indication that the item would then be filed?
No,
Did you give him any indication with respect to what would be done with the item?
I didn't have a conversation with him, so no.
Have you not testified to having some conversation with him today?
I spoke a couple of words, but I wouldn't say that we had a conversation.
What were the words?
She's asked and answered that now 3 times. I've written this down. You're asking the same question over and over. I'm not going to allow her to answer that because she's answered it 3 or 4 times. So that's the next question. Either you're not paying attention or you don't remember because I have written notes on it.
I do remember, and she contradicts herself every time she
Next
answers a
question,
question.
Mr. Coughlin. We're not going to have an argument about your asking her improper questions. Next question.
I understand your.
You're free to ask quietly. Let me tell you, we're at 1:30. I'm going to give you 15 more minutes of cross-examination. You testified earlier it's going to be substantial. I told you no, it wasn't. Because we're not going to spend all day asking her questions 3, 4, and 5 times.
Yes, sir.
So if you want to wrap it up and narrow in on some questions, go ahead.
Okay. Did you write in your January 3rd, 2013 police report, I got into my car and saw Zach parked in the street at the end of the driveway?
If that was in the report, I probably did write it, yes.
Was that true?
I didn't see you personally, but all indications were that it was you at the end of the driveway.
Did you write that in the report, though?
Apparently so, yes.
Why did you phrase it that way?
That seemed like a reasonable statement.
Where you wrote, I got into my car and saw Zach parked in the street at the end of the driveway?
I suppose I could have said Zach's car.
Why didn't you?
I don't know.
And where did you write, yesterday evening Mr. Coughlin parked his car at the end of the office's complex driveway?
If it's in the report, that's the report that I submitted.
I'm asking you whether or not you know you wrote that.
As I'm sitting here today, I can swear that those were the exact words, but if you're reading them off a piece of paper, I'll take your word for it.
Your Honor, I'd ask to be able to refresh the witness's recollection in that regard and impeach her testimony.
She'll work with a copy to the marshal. He'll show you a copy of the police report. You can ask some questions.
Yes, sir, Your Honor.
And do your best to answer it. You can remember, you can't remember, you're not sure. Whatever is the truth, just testify to that. So, you have a copy of her statement?
I believe so, Your Honor. Just 1 second. I don't have a copy of it. I was up in the courtroom.
Well, I don't have a copy of any police reports. I don't look at police reports. I don't look at the criminal complaint. I have no recollection of the police report.
Well, I mean, I have a copy. I need a copy to provide.
Go ahead and show it if there's a copy of her witness statement. Go ahead and show it.
But I'd like to have it marked as an exhibit as
So
well.
marked as Mr. Cochran's first and one for identification.
This is actually part of it too, and I believe this is also.
That's your written statement?
This is the entire police report.
No, we're not going to show her the entire police report. She can look at her statement.
Well, I'd like to have these marked as exhibits.
Mark, all you want, sure.
And if I can have copies provided to City Attorney Wong and
That's number one, let me see that.
a copy for the witness to.
Number one.
Defendant's number one is not a copy of, defendant's number one is a series of documents, Mr. Collins. It includes your mugshot profile, memorandum from the municipal court from the city attorney's office, a copy of the PC sheet by Officer Uturbity, and a declaration in support of arrest, summons is blank, and also is a declaration supplement from Officer Uturbity. The police report, page 1 of 4 from Officer Uturbity. The next page is a temporary order for protection. That one page contains 2 pages, like they all do. So then it goes on. There's no defendant one. It's been marked as you have a right to have it marked as it has nothing to. No statement from Ms. Peters.
Is the court making a statement that that's not the police report?
It's a series of documents, and some of it is not the police report. No, that's correct. I just read it to the record what it is.
I submit that it's no different than Exhibit F in that.
Exhibit number 2 is a. Let me finish, Mr. Coffin, please. Exhibit number 2, and each one of these pages contains 2 pages shrunk down, is a police report. Case number 13-2445 from Detective Uturbity. The next page is a declaration supplement, page 1 of 3 of a police report.
I understand, Your Honor.
3, I'm reading into the record, page 2, page 3 of the same police report is included. Page 1 and page 2 again mirror as another police report from Detective Uturbity. Some of these pages are duplicates. In fact, a number of them are simply duplicates. There are police reports from Detective Uturbity, the front of which is Defendant's Exhibit 2, which is a facsimile. So there you go.
We did not take this time to go through Mr. Wong's Exhibit F and Exhibit C.
I've had what you've requested to be marked as your defendants 1 and 2. They have been marked. And these aren't in. We got Mr. Coughlin. These are not in evidence. They're simply marked. And let's go ahead.
And I asked,
Do you want all these documents attached to Exhibit 1 as part of Exhibit 1? Is that what you're asking the court to do? If you want them, I will.
I would like the police reports relative to the TPO to be one exhibit and relative to the EPO, unless this court prefers.
No, you tell me. I'm not going to tell you
Well,
which
I think
exhibits
it might-
mark. You tell me which exhibits you'd like marked for the court to consider.
I'd like the one that is relative to the EPO to be Exhibit 2 and the one for the TPO to be Exhibit 1.
And I have not seen what documents you have. You put
You
together.
just read them into the record and characterized them as not a police report.
No, don't mischaracterize what I've had to say, Mr. Coughlin. Those documents contain a differing number of items. They include the facts page. They include declaration of booking photos. They include unsigned summonses, and they do include part of the police reports. That's what I read into the record. You need to have those stapled together, and you can deliver to me any documents you'd like the court to consider. They're your documents. They're your exhibits, not mine nor Mr. Wong's.
May I have the stapler that Mr. Wong was permitted to use in that? I'd ask, may I approach and provide these to the witness to engage?
I want you to simply put together whatever exhibit you want to put together, so they're attached as one exhibit. So do it in any fashion you deem to be appropriate, staple together whatever you would like to be considered.
I've asked to admit Exhibits 1 and 2, Your Honor.
Show those to Mr. Wong.
You got both copies of 2. Clerk Peters, during the 1-4,
Wait a minute, you've asked that some exhibits be marked with evidence. I've asked that you look to Mr. Wong for his response, then I'll make a ruling. Mr. Wong? Do you have any problem with those coming in?
No, Your Honor.
All right. Coughlin, your exhibits number 1 and 2 are both admitted into evidence. I need exhibit number 1.
yeah, make copies for you. Okay.
Okay, 1 and 2 are now in evidence.
Thank you, Your Honor. They're admitted.
They're admitted into
That's what that
evidence
means.
over no objection, yes.
Okay. During the January 4th, 2013 extension hearing in the Justice Court in the 607 case, Clerk Peters, did Mr. King, in response to Mr. King's question, and could you describe what occurred last night, put forward to you, did you respond that oh, I'm sorry. In response to Mr. King's question, with respect to whether Mr. Coughlin was in the car at the time, is that correct? Did you respond yes?
I don't remember. I don't remember him asking me that.
Okay. In response to Mr. King's question, can you describe what occurred last night? Did you respond, last night at a little bit after 5, another employee and I were leaving the building and a man came up, walking up to the door just as we were about to lock it. He had in his hand some paperwork from Zach, and to Zach's credit, he didn't come himself. He sent somebody who was waiting at the end of the driveway. He had some paperwork with, and the guy said, I want to file this. And I said, you're not going to file it, and I threw it on the floor because he was trying to stuff it into the door, and then we just locked it, and he left too. Did you testify to that effect at approximately 9:38 a.m. on January 4th, 2013?
I don't know where you're reading that, but that sounds generally like something that I would have reported.
Is there a reason why when in your sworn testimony on that date that you reported that you saw Mr. Coughlin there that day to Judge Pearson at the time in which he was deciding whether or not to extend the protection order?
I don't remember exactly what my words were. If you're reading that off of the...
It's non-responsive. The question's been asked. The question's been answered. Next question. I'm giving you 10 more minutes.
It's non-responsive, but it was answered?
It was answered.
Okay. Did you fill out, in Your Honor, if I may have marked and copies provided with this transcript of the January 4th, 2013 protection order
You
hearing?
have Mark, whatever you want, just get it together. We'll make that'll be your exhibit number 3.
Just to be clear, it's all scratch paper on the back in all these instances. Sorry. It's a transcript with some commentary and footnotes.
I remind you, you got 10 minutes of cross-examination left.
Yes, sir, Your Honor.
10 till I'm ending the cross-examination. We've spent over an hour and a half on a lot of irrelevant matters, so if you want to zoom in on anything, you can do that.
Yes, sir, Your Honor. Any suggestion would be welcome as to what areas the court would...
No, you're making headway as long as you stay focused on the relevant questions about the statements that were made that she saw you, that she thought it was you. Those are all relevant, fair questioning, and those are you did a good job on that.
Yes, sir, Your Honor. Thank you. Clerk Peters.
Your Honor, I am going to have objections to this exhibit, but I'd like to have a copy made and so I can refer to...
Let's have a copy made from Mr. Wong. If you want to continue to ask any questions, you can go ahead.
Yes, sir. Clerk Peters, when you say you stopped the facts of January 17th, did it occur to you that part of your duties as a clerk of court might be to retain copies of any submissions or filings submitted to State Bar yourself as clerk of court of it?
No.
Do you have any such duties as far as you're aware?
under normal circumstances, I would accept documents for filing either by hand delivery or through the mail.
Objection not responsive.
Well, you ask a question, she gives an answer, then you object. You're stuck with the answer.
Even if it's non-responsive. Okay, yes, sir.
I don't think it's non-responsive. I think she answered your question. So as far as I'm concerned, it was responsive, so your objection is overruled.
Yes, sir. Did you have any filings submitted by a facsimile by the defendant Coughlin during the pendency of the TPO?
No,
Did you receive any facsimiles from the defendant Coughlin during the period between December 20th, 2012 and January 4th, 2013? Or the State Bar?
just the one that I reported on.
And that was on January 17th?
Right,
Objection not responsive.
so that's outside your scope.
Listen, there's no question. The question you asked was responsive. You may like the answer she got, but she answered the question.
I understand. Your Honor, I'd ask to have Exhibit 3 admitted into evidence, just to comply with my duty of candor and the Sierra Glass professional conduct proviso. It's not, perhaps, it is a verbatim transcript, to the best of my knowledge, from, I believe, pages, those materials not in footnotes.
Mr. Wong?
I have an objection to the defendant Exhibit 3 on a number of bases. Number 1, authentication. Number 2, this has not been provided to me in discovery. Number 3, while it does appear to be, for the record, it appears to be 2 pages of documents per one 8.5 by 11-inch sheet. And while it does, the initial pages do appear to be a transcript, there are markings on that which make me believe that the actual transcript has in fact been altered. Those markings include bolding of letters, underlining of letters, insertion of website links. And so while Mr. Coughlin reports this to be the transcript of the January 4th, 2013 EPO hearing, it's really apparent that it's not authenticated and it's an altered copy, not provided in discovery, and the end of the transcript includes, well, from the 8th page on, it's not a transcript. He purports it to be a transcript of the January 4th hearing, but it's not a transcript. It appears to be just argument. It does pick up again transcript on a subsequent page, but then it just appears to be a lot of footnotes that are not part of the transcript. So if he's purporting this to be a copy of the official transcript from January 4, 2013 EPO extension hearing, then it clearly is not.
Your Honor, may I respond to that?
Yep.
That goes to some of these issues under the NRS 189.30 sub 1 analysis with respect to voice transcribers and certified court reporters. That is something I myself voice transcribed from page 1 to 8, and Chief Wong is correct to the extent, and I was remiss not indicating that verbally. I do think it's indicated within the text of this item that the emphasis within those first 8 pages, which are what I understand to be a verbatim transcript of, at least textually, absent formatting, it's a verbatim transcript of the approximately 30-minute long hearing on January 4th, 2013 in the 607 RJC case. The links...
Yeah, well, why don't you focus in? We're running out of time. You're spending, again, 5 minutes just kind of rambling on, and I want you to tell me why you think this is admissible. The longer you talk doesn't make the argument, doesn't make the document more admissible.
I think it goes to the weight of the evidence rather than its admissibility, and it's got relevance in terms of impeachment, particularly with respect to Clerk Peters' earlier testimony that she did not testify at such hearing, that she...
All right, let me make a ruling, Mr. Coffin. You're just rambling on now, and it's not helping. I'm not going to admit Defendant's Exhibit 3. It's not because it wasn't part of discovery. It's because it's not properly authenticated. It contains lots of extra materials in here that aren't part of the record. So it's marked and noted that it's not admitted into evidence.
Your Honor, it's self-authenticating to the extent it's not...
Thank you, Mr. Coffin. It's not admitted.
Okay, if I may continue my proffer as to...
You have 5 more minutes of cross-examination, and then I'm going to let Ms. Peters off the stand, so go ahead.
Okay, but this is marked as
It's
part of
marked.
the record.
That'll be part of the record. We'll take it as part of the record. I'm just not going to consider it as evidence.
And if I may have
Yes,
a
ma'am.
copy of it as well.
Well, did you not make a copy of this?
I don't believe I have a copy with me, but to the extent...
We'll get you a copy before you leave today, Mr. Wong. Let's make a copy of Mr. Wong's, and we'll make a copy of this and give it to Mr. Coughlin. Let's go ahead and make a copy of that one. All right, go ahead. You got 5 minutes left. At 5 till, I'm terminating the examination, because you're not going to have an unfettered right to sit here and keep her on the stand all day because you want to ask questions that are way out there, so go ahead.
Yes, sir. Did you testify at the extension hearing that you were a paralegal with the State Bar of Nevada?
Yes, probably I did.
Is it
I don't
yes,
know.
no? Okay.
I don't recall exactly how I identified myself.
Did you in any way identify yourself as a clerk of court or a court clerk at that extension hearing?
I can't recall.
Do you feel that would have been a material circumstance to bring to the awareness of the court?
No.
You say earlier you testified as to there was no matter pending, I believe, during the times in question, January 3rd, January 17th, 2013, with respect to the respondent Coughlin here. Is that correct?
Yes.
Are you aware of any extent to which Supreme Court Rule 105 requires a respondent and or his attorney to confer with the State Bar in several respects, including as to matters related to the record and or appendix?
That's irrelevant. You don't need to answer that question. That's irrelevant.
Your Honor, if I may make a proffer.
You're down to 4 minutes, so go ahead.
She's testified. She found it was
You need
relevant
to
when
argue
she
with me.
testified.
If I was you, I'd be asking her questions. I wouldn't be spending the time arguing with the court.
Okay.
It doesn't seem to go anywhere.
Why did you testify earlier as to your belief that there was no matters pending at that time?
Because at that time, January 3rd and January 17th, the record was in the hands of the Supreme Court. We don't, once we're done with the disciplinary process and release the record, we don't have any jurisdiction anymore as far as I understand.
Did the respondent in this matter file any tolling motions?
Not to my knowledge.
Are you aware of what a tolling motion is?
Yes.
What's your understanding of what a tolling motion is?
Well, essentially, it kind of buys you time. It stops the clock until the next incident. And we don't, I can't think of a circumstance when that would even apply here. but
Relative,
no, I don't remember you filing anything to toll any.
relative to the December 14th, 2012 findings of fact and conclusion of law, and ostensibly the recommendation of panel chair, the panel and or
That
the
was-
chair, did the respondent file anything or submit anything that you chose not to file, or that Assistant Bar Counsel King ordered you not to file, that was responsive or in any way connected to that findings of fact of December 14th, 2012?
Objection, compound question.
It's a total compound question. We're down to 3 minutes, Mr. Kaufman.
Did-
We'll wrap it up with a
did
series of 3 or
respond-
4 more questions.
Did the respondent file anything subsequent to the December 14th, 2012 findings of fact by the panel chair?
If you know, you
I
can
don't
answer that.
recall.
If you don't, you can. Okay.
Did you not just testify that the respondent did not file any ruling motions?
As far as I know, you didn't, no.
Wrap it up, Mr. Kaufman. A couple more questions.
Was the record on appeal that you filed with the Nevada Supreme Court on December 24th, 2012 stricken by Chief Justice?
That's irrelevant. That's an irrelevant question. Next question. That's irrelevant.
Your Honor,
I've made my
Progress.
ruling. It's irrelevant.
okay.
You know, we're not going to have arguments about my rulings all day. They're irrelevant.
I understand, Your Honor. I think some of the time, I'm not aware to what extent I need to put exceptions into the record.
You
or
get
something.
2 more minutes of questioning, Mr. Coughlin. Any questions we'll have from Ms. Peters related to what she testified to today earlier that you have not already asked her numerous times?
Did anyone with the, did you fill out the protection order application in this case?
I believe I did, yes.
Is it your handwriting on that TPO application?
I think so.
Was that TPO application filed in part to protect yourself?
All the people in the office, including myself, yes.
Would that include Assistant Bar Counsel King?
I suppose it would, yes.
Did you white out your name from that TPO application where originally you had signed it?
I don't know.
Your Honor, if I may have marked Exhibit C, which is a portion
The
of
Exhibit 4. Then it's Exhibit 4.
Yes, sir. I'm sorry, I didn't hear you, Clerk Peters. Did you indicate that you had somehow whited out something from that application?
Possibly, but not to my recollection.
Why do you say possibly?
Well, if you're looking at something that's whited out, I can't say that I did it or didn't do it. I don't know.
Did you at some point become aware that an employee is not permitted to file a workplace harassment and protection order on their own behalf?
Yeah, that's not good. It's irrelevant. That goes to collateral issues related to the issuance of the protective order. Judge Dilworth has previously ruled in the motion in limine in pursuant to Truesdale, but that's irrelevant, so that's a question that need not be answered.
Yes, Your Honor.
Is that this morning the types of copies
Submitted that goes to the voidness and voidability of the order rather than
Thank
the
you.
validity. Or
And we're going to wrap it up with the arguments regarding your exhibit number 4, and that's it.
Yes, sir.
We'll skip what happens made from Mr. Wallen.
Clerk Peters, did you file a October 9th, 2012 affidavit of Laura Peters in this disciplinary proceeding of issue?
That's irrelevant, Mr. Kaufman. We're going back to an event that happened 4 months prior to these incidents and have nothing to do with these incidents, so that's irrelevant.
Well, if I can make a proffer as to how that's relevant, Your Honor.
You're out of time. Go ahead. Go ahead.
That October 9th, 2012 affidavit of Ms. Peters was Ms. Peters and Bar Counsel King's attempt to ameliorate the extent to which Ms. Peters on September 11, 2012, had expressed that Coughlin was indeed permitted and entitled to submit findings via facsimile.
Well, that doesn't make, her belief that you can file things doesn't make any difference. In fact, if she allowed you to file anything, you have, the allegations in this case is there's a court order that prohibits you from filing.
So there's not.
Whether or not,
contacting.
whether or not Ms. Peters allows you or disallows you is irrelevant to this case.
Yes, Your Honor. And so, just to clarify.
We don't need to clarify anything, Mr. Coughlin.
Well, it affects
Go
all
ahead
my
and ramble on
questions.
if you'd like to.
Well, it affects all my questioning from here on out. If you're indicating.
No more questioning, we're finished with cross-examination. You've been here all day, you're asking questions that are irrelevant, that are duplicate, duplicitous, and outside the scope of direct examination. I told you 45 minutes ago I was going to wrap this up, and I've given you another extra half an hour.
That's the first indication you've made that any filing is tantamount to contacting while without their order. Which would, as I understand it, preclude filing by mail as well.
I don't know, I haven't considered, I haven't heard all the evidence, I don't know what's against the law, what is prohibited or not, I haven't made my determination. I'm looking at Defendant's Exhibit 4, which again is a series of 4 documents per page that appears to be the application for the temporary order for protection of violence on one page. On another page throughout this document, there's a letter from the State Bar to you from Patrick King. There's an order from John Echeverria, the hearing officer. There's a certification of service from Laura Peters. There's findings of facts, conclusions of law that are four to a page that appear to be, though I'm not sure, from the Northern Nevada Disciplinary Bar Panel from John Echeverria. And there's a certificate of service. There's some, as we get into the document, there's some miscellaneous emails and more irrelevant items that don't make any sense, along with a copy of at least a signature of Judge Pearson and a broadcast report, and then there's finally something from Patrick King. So you want to, Mr. Wong, you need response to Mr. Coughlin's offer to have Defendant's Exhibit 4 put into evidence?
Your Honor, when Mr. Coughlin offered this, he indicated that it was the application for temporary order for protection against harassment in the workplace. This copy does appear to be a file stamp, however, it's not authenticated. It's not a certified copy.
Well, it's also a copy of like 7 or 8 or 9 different things contained in here.
Which I think were the exhibits to the application, but we don't know for sure, because we don't have a certification that these are true, fair, and accurate. So I would object based on authentication.
Clerk Peters.
No. The exhibit number 4 is not admitted, and we're done with cross-examination, Mr. Coughlin. Can you redirect examination, Mr. Wong?
No, Your Honor.
Thank you, Ms. Peters. You can have a seat or remind you to discuss the testimony.
Your Honor, that would be the city's case in both cases, 13 CR 03913 and 13 CR 03914.
All right. The city is rested. Mr. Coughlin?
Your Honor, will I be afforded a basis to proffer why Exhibit 4?
It's irrelevant. It's irrelevant. It's a series of documents. It has nothing to do with this case. It's I've made a finding that's irrelevant to the case.
It's the TPO application at issue in this case.
It's irrelevant.
Okay, but
What's
that's not
relevant
why
is
you
whether or not an order.
used it earlier.
No, I've said it's irrelevant.
You
It's
said
an
it wasn't
application.
certified.
No. I know, Mr. Coughlin. I did not say it wasn't certified. If that was not what I said it was not relevant. And it's a series of documents in there that make no sense to the court, but it's not relevant. So that's why it's not admitted. I'm not going to have an argument with you. It's not admitted. It's part of the record. It's going to be part of the court record. It's in the record, but we're not going to sit here and argue about it. So that is not, it's admitted, but not, it's marked, but not admitted. And where is number 4? Can I get the other exhibit over there?
Yes, sir.
So we've got 1, 2, 3. Where is number 4? Mr. Coughlin, do you have number 4? Do you want that part of the court record?
Yes, I do.
All right. I got it right here, all right? All right, your time for your case in chief, Mr. Coughlin.
The city rested?
The city has rested, yes.
Okay. Your Honor, if I can just indicate to the court, with respect to Exhibit 4, I believe the last 2 pages thereof are they're essentially 1 page per page reproductions of previous pages included in what is not a series of, I mean, it's not as though I put these documents together. This is the State Bar's TVO application. I had nothing to do with what they chose to put in it. But those last 2 pages, I believe, are essentially not part of that.
You want me to take the last 2 pages off this Exhibit 4 for consideration, or you want me to leave them in? It's up to you.
Well, it's not admitted anywhere.
Well, it's part of the record. I'll either take these 2 off, or I'll leave them on.
If we
That's your
can
call.
take them off and then, well, just leave them in. I won't be permitted to make them Exhibit 5. It's just kind of a blown up copy of the whited out page.
All right. All right.
Page
Exhibit 4 is now part of the court record.
where the check marking on page 6 of 6
Mr. Coughlin, do you intend to call any witnesses?
was in blue ink rather than black. Yes, I do.
Okay, who do you want to call as your first witness?
I can call. Sorry, Your Honor, I didn't get to eat at lunch, given that you directed me to spend my time at lunch doing that.
No, I didn't direct you to do anything, Mr. Coughlin. I took an hour break. What you chose with your lunch was your business. So who do you want to call as your first witness?
I'm just wondering if I could have a 10-minute break to perhaps grab some
Yeah, you
water.
can have a 10-minute break, sure. Well, it's 2:05. We'll resume at 2:15. Take a 10-15-minute recess.
Yes, sir, Your Honor. If I could call Patrick King, State Bar.
All right, go ahead and see here.
No.
Did you subpoena him?
He was under subpoena.
Can I see the subpoena?
Chief Wong.
He's not here. If you didn't subpoena him,
he might have just identified him as a witness.
if you didn't subpoena him, Mr. Coughlin, you can't expect Mr. Long to have him here.
And I might be wrong in that respect. I thought he was subpoenaed by Mr. Wong.
Well, Patrick King is here. You can call if he's not here. There's no one to.
I think, Lord, well, if I can go out in the hallway and see.
Go check and see if Mr. King's present. Thank you. Can you put 2 hold? Nope, all right. Mr. King is not present.
All right, then I'll call Laura Peters.
She just testified, did she not, Mr. Coughlin?
She testified on cross.
All right, let's bring her back in, put her on the stand. You can ask her some questions. I'm going to tell you that we're not going to go into we're not going to repeat any of the same material we've raised the last 2 hours this morning. So anything you want to ask her new, you can do that.
Could I call actually Detective Turbity prior to that, Your Honor?
Is Detective Turbity here?
I don't believe so.
Can we get him over here?
And I would also add, Your Honor, that Mr. Coughlin has not provided.
All right, that was my next question.
Notice of any defense witnesses.
All right, Mr. Coughlin, do you want to address that? What your responsibilities under NRS 174-245 and your responsibilities under 175-234?
I believe I did identify.
Can you produce your notice of witnesses? Can you show me what you've provided to the city?
I don't believe I have that readily available.
Mr. Wong, you want to respond to that? I mean, did you get anything from Mr. Coughlin pursuant to discovery statutes indicating what witnesses he intended to call in this case in chief?
I did not receive anything from Mr. Coughlin in either case entitled anything near or similar to, quote-unquote, notice of witnesses. Mr. Coughlin reminded me this morning that he sent me many emails with many attachments, and he made allegations about my having received certain documents, and quite frankly, I couldn't admit or deny them because I don't have time to read in detail all of his multiple attachments to his multiple emails. But I will say clearly, I didn't see any attachment or any email or any kind of communication in writing from Mr. Coughlin that said this is the notice of witnesses, or these are the witnesses I'm going to call, or anything like that.
Did he provide you with written statements as required by NSA 174-245-1A?
No.
Mr. Coughlin, do you want to respond? Do you have an obligation for any witness you intend to call during the case in chief to provide written or recorded statements made by that witness to the city? Additionally, under 174-234-B1, if you're punishable for a misdemeanor in the state, you shall file and serve upon the prosecuting attorney a written notice containing the name and last known addresses of any witness you intend to call during your case in chief, whose name and last known address have not otherwise been provided to the prosecuting attorney. Now, Mr. Wong has done that. Is there a reason you have not done that, or have you done that?
I believe I've done that.
Okay, let me see proof of it.
And Mr. Wong just admitted he wasn't sure whether I had it.
Let me see the proof. Let me see the proof of that notice, the 174-234 notice. Let me see that.
I asked that Mr. Wong show proof that he didn't.
No. We don't prove a negative, Mr. Coughlin. You have an obligation, just like the city does, to provide the names and addresses of witnesses that you intend to call in your case in chief. You have an obligation under 175-245, same as Mr. Wong has the reciprocal obligation to provide written or recorded statements made by any witness you intend to call during the case in chief. And I'm asking you to show me proof that you did that.
Yes, sir, Your Honor. I said one basis for that is the court to take judicial notice of the filings of 5-1, 5-2, 5-13. This is all 2013. 5-13 and 8-14, I believe, 2013. Additionally, Mr. Wong, I don't believe I have a duty to file notice or proof or even produce such to the court. I understand it's.
Well, the statute mandates it, both statutes, 174-245, and looking at them with 174-234, they make it mandatory.
That it may be filed, or that merely...
Let me read it for the third time today. I ask you to listen this time. 174-245, entitled Disclosure by the Defendant of Evidence Relating to the Defense and Limitations. Subsection 1 says, except as otherwise provided in 174-233 to 174-295, inclusive, the defendant shall permit the prosecuting attorney to inspect and copy and photograph any written or recorded statement made by the witness the defendant intends to call during the case in chief of the defendant, or copies thereof, within the possession, custody, or control of the defendant, the exercise of which is known, or by the exercise of due diligence may become known to the defendant. Interest 174-234, 1B, provides that if the defendant will be not tried for offenses that are punishable as a gross misdemeanor or felony, and in this case you're being charged with a misdemeanor, the defendant shall file and serve upon the prosecuting attorney a written notice containing the name and last known address of any witness the defendant intends to call during the case in chief of the defendant, whose name and last known address have not otherwise been provided to the prosecuting attorney pursuant to the previously mentioned 174-245. Mr. Wong is in compliance with both 174-245 and 174-234, and I'm asking you if you're in compliance, and if you're not in compliance, why should you be relieved of the same obligations of every defendant to provide that information?
Yes, sir, Your Honor. As I understood what you read, 245 or 234 of 1B is only necessary if such has not been provided within the context of 174.245, which does not require filing. Regardless, I believe I have done it both in and outside the context of something filed, on file.
Well, why don't you point that out to me so I can see it? I'm asking you to point it out. I'm not asking to root through these records. You show me where you provided notice to Mr. Wong of the witnesses you intended to call during your case in chief, the reciprocal obligation you have.
To provide notice, I don't have an obligation to prove to the court.
Show
what I
me
did.
whatever you provided. Let him know who you're going to call as your witnesses in your case in chief.
And I believe.
I mean, why?
I also provided.
Go ahead.
I provided Chief Wong the very materials that he provided to me, and further, which would satisfy that obligation. Further, specifically, but not limited to such, I'm referencing the police reports that were provided, including Detective Utilities for both the 3913 case and the 3914 case. Under 178.598, facsimile is
Mr. Coffin, it looks like you didn't provide that information. Is that correct? Either you did or you didn't.
No, I believe I did.
Well, I want to see it. I'm not going to, you show me where you provided proof. In the meantime, where's Officer Uturbity now, Mr. Wong, Detective Uturbity?
I don't know, Your Honor. I believe he's back working.
Right, Mr. Coughlin, tell me where you showed proof of
Then
that.
I moved for continuance to the extent he's not here. He was clearly told he was still under subpoena.
Let's get him back over here then. Let's get him back over to call the police department, get him back. You know, Mr. Coughlin, your total non-compliance with the rules. You did not comply with 174-245. You did not comply with 174-234.
In terms of
what I've referenced now for the fourth time, providing a list of witnesses you intend to call during your case in chief of Mr. Wong, along with their names and addresses. And I don't know why you think the rules don't apply to you.
that's not the case.
Then why didn't you comply with
The
that
rules
statute?
don't say I need to be able to, on command, come to the trial and provide proof of that. And in fact, they don't even say I need to file it.
The defendant shall file and serve
And that's in
upon the prosecuting attorney. Did
Where-
you do that?
where 174.245 is not in play.
Well, 174-245 is in play. Did you provide written or recorded statements made by the witness the defendant intends to call during the case in chief? Did you provide that? If you intended to call Detective Uturbity, did you provide copies to Mr. Wong?
Yes.
You did. When did you do that?
Well, on a number of occasions.
Okay, listen, I'm going to let you do this. I'm making a finding your total noncompliance with the discovery statutes. Notwithstanding your noncompliance, we're going to get Officer Uturbity over here and put him up on the stand. But we're not going to rehash all the information that we went over this morning on direct and cross-examination. If there's new information you'd like to elicit, I'll allow it, but we're not going to go into any of the other items over and over. So we essentially start not making use of the, we start wasting judicial time because you're not, because you want to sit here and ramble on.
Yes, Your Honor, and I'll do my best not to do that.
Well, we're not going to let you do that, so let's get him over here.
Well, I'm confused at this point because previously when I was questioning these witnesses, a lot of the curtailing of such inquiry was relative to what was raised on direct, and now it seems as though the court is telling me just in general, regardless of whether it's direct or in your case in chief.
We're not going to let you go off on a diatribe on irrelevant evidence. I'm going to let you know that right now. The evidence in this case is going to be directly related to the individual witness's role in the investigation of this case.
I'll go outside and call.
Who's here now? Is anybody here now?
There was one in the halls.
Right. What other witnesses do you intend to call, Mr. Coughlin? You intend to call everybody back that testified? Is that what you're going to do?
Your Honor, it seems as though the way you're saying that.
No, I'm asking you as a simple question. Are you going to call them back or not? I want to know.
Everybody.
Everyone who's testified, that'd be Bailiff Anthony English, Detective Clint Player, Officer Tom Uturbity, and Laura Peters.
I doubt Bailiff English or Deputy Player.
Okay, so you intend to call back Tom Uturbity and Laura Peters?
Yes, sir.
All right. Is Laura Peters still here?
No, Your Honor.
We need to get her here too.
Okay.
show up, let me know.
Yes, sir. Right.
Sir. Go ahead, Mr. Coughlin.
Good afternoon, Detective Uterby. Thank you for returning this afternoon. Can you describe how you came about to be assigned this case?
It's assigned by my sergeant,
And who's that?
Sergeant McCauley.
And when did he do that?
I don't know the exact date. It's in January.
Was it about January 25th?
Sounds right.
When was the first report received from the State Bar of Nevada of an alleged violation
Received by the state.
received by the Reno Police Department?
I don't know the exact date.
Do you know whether Clerk of Court Peters filed a police report on approximately January 4th?
That sounds right.
Yet it wasn't assigned to you for some 20 more days?
Yes, sir.
Is there a reason why that might be?
I don't know the answer to that.
Do we have Ms. Peters on the way back over?
Your Honor, what happened is I called the direct office line at the State Bar that I have for her and got her voicemail. I then called the other State Bar number, talked to personnel who indicated that they would attempt to get a hold of her by a cell phone. They reported back to me that they were unable to get through to her because her cell phone mailbox is full. They gave me the number. I also called that number and received the same message that her cell phone mailbox is full. I did send her a text. I don't know if she got it.
All right, thank you, and excuse the interruption, Mr. Coughlin, go ahead.
Yes, sir. Detective Uterby, is your normal position with the Reno Police Department investigating misdemeanors?
I'm assigned to the Family Crimes Division.
I can't hear you, I'm sitting right here.
Sorry. I'm assigned to the Family Crimes Division.
So regardless of whether it's a misdemeanor or a gross or a felony?
Whatever's assigned to me.
Okay. Is there something in your police report that indicates anything with respect to just being assigned to misdemeanors or maybe being not assigned to misdemeanors, but rather typically only a gross and felony?
I don't understand the question, Mr. Coughlin, rephrase the question.
Is there something in your police report that would indicate that it's unusual for you to be assigned a misdemeanor TPO violation case or cases?
No.
Okay. Do you typically handle misdemeanor cases?
No.
What do you typically handle?
Whatever's assigned to me.
Does that include misdemeanor cases?
Yes.
Is it atypical for you to be assigned a misdemeanor case?
It's asked and answered. He's already answered. It's not unusual to get it. He gets everything. Ask another question. We're not going to go through this afternoon and have you ask the same witnesses. I don't know if you're listening to what they're saying, but I write it down, and once they've asked the question, I want you to ask a different question.
Yes, Your Honor. My understanding is he said it wasn't typical.
I said he handles misdemeanors, felonies, and gross misdemeanors, whatever assigned to him. Ask another question, unrelated to that question.
Okay. Had you ever heard of the defendant, Coughlin, prior to your being assigned this case?
Yes, sir.
How's that?
It's been in other cases.
And how were you made aware of such?
Through the police department.
By who and what did they communicate to you?
I can't name specific people
Why is that?
because there's been several different ones.
Is there something about the fact that there's more than one that prevents you from naming?
No, sir. I just cannot recall every single person.
Well, can you recall some of them?
Not off the
Objection
top.
relevant.
What's the relevance, Mr. Coughlin?
Well,
I want you to give me the answer. How is this relevant?
I believe Hartman provides the basis for the position that vindictive or retaliatory arrests or prosecutions are relevant to the issue of guilt.
The objection by Mr. Wong is overruled. Go ahead and ask some questions. But again, Mr. Coffin, I don't want to limit your cross-examination, but we're not going to be here for hours as you kind of just randomly ask questions. I want you to ask specific questions. There comes a beginning and an end to cross-examination. It's not going to ramble on here all afternoon. It's not an unfettered right on cross, and this is a witness on direct. It's also not an unfettered right to simply ask questions ad nauseum. So go ahead.
Yes, sir.
I'm going to limit the questions if I feel they're not relevant, whether or not there's an objection by the city or not.
So can you answer that question, Detective Richard?
What was the question?
Specifically, whom at the Reno Police Department had you conferred with regarding Defendant Coughlin prior to your being assigned this case, and what was the substance of those communications?
I have not conferred with anyone. It's information that was passed.
Okay. By whom, and what was that information?
Information with previous dealings with Mr. Coughlin. I do not know the specifics of each case because I was not involved in them.
Well, just any specifics that you remember.
I can't remember anything off the top of my head, sir.
You say you can't remember everything?
Anything off the top of my head involving you?
Not anything.
No, sir.
Yet you remember you didn't confer with, but you were informed
Yes, sir.
by individuals employed by the Reno Police Department.
Yes, sir.
Why?
Why what? I don't understand.
Why was he informed of materials that he can't remember relative to Defendant Coughlin prior to his even being assigned this
You
case?
can answer that, Detective Derby. If you can, you can.
It's just information passed through the police department.
There's objection and responsible.
Overruled. Go ahead.
What information?
I don't know the specifics. It's information with previous dealings. I was not involved in those dealings. Members of the police department were.
You can't recall any.
No, I was not involved.
Okay. And I'm sorry, Your Honor, if I missed it, but has the witness been sworn?
The witness has been sworn. I reminded him he was under oath and took the stand this afternoon.
Yes, sir. Thank you, Your Honor. Do you know an officer, Nicholas Doral, I think is how it's pronounced?
Yes, sir.
How do you know him?
We've worked with the Reno Police Department together.
When you were a detective, or?
We've never worked specifically on the same team. I just knew we were employed by the same employer.
And approximately how many officers are employed by that employer?
I have no idea.
How familiar are you with Officer Doral?
No, I'm in passing.
Do you know his wife?
Objection as to relevance. Mr. Coughlin, go. Make your questions relevant, please.
How do we know it's relevant?
I'm ruling it's irrelevant. Then move on to your next question.
May I offer why I believe it's relevant?
Go ahead.
Officer Uturbity's wife is an e-com dispatcher. I've been
I
prosecuted.
don't know that to be a fact or not.
Well, I need to have an opportunity to establish
I
that.
want you to establish whether or not he knows this other officer's wife is relevant.
Well, I think under Twombly and Hartman, vindictive and retaliatory prosecutions and arrests are relevant to the determination of guilt.
When you start laying the foundation, there's possibly a vindictive retaliation. I may allow that question until that is established. The objection is that it's irrelevant and you're not going to make any inquiry regarding that. Next question.
Okay, and so I talk about laying a foundation.
Next question, Mr. Coughlin. I'm not here to give you legal advice.
Is your wife a e-com dispatcher?
Objection is to relevance. It's not relevance. I'm not going to go into those type of questioning. That's not going to happen, Mr. Coughlin. Next question.
And I'm not sure what you mean by that type of
We're not
questioning.
going to any questions about the officers' wives related to Detective Uturbity's receipt of evidence from the State Bar. Your focus should be limited and not only it gets to be so irrelevant that it's problematic to the court.
Even if Darrell's wife's a dispatcher too, and Darrell's
Ask your next
wife's
question.
kid
I'm not going to
arrested
have an
me?
argument with you. Ask your next question.
Okay. What did you charge the defendant with here?
I believe it was a violation of a TPO and a violation of an EPO for the workplace.
What statute?
I don't know the specific numbers.
Do you know generally the charge?
I can add the filing document speaks for itself in this case, Mr. Coughlin. It's amended criminal complaint. The charges were levied by the city attorneys for NRS 33.350 in both cases.
I didn't ask what the complaint was. I asked what his charge was on his declaration.
I'm answering the question. That's the statute that you were charged with.
You're asking a
Ask
question I
another
didn't
question.
ask.
Ask another question, Mr.
Okay, I'm
Coughlin.
going to ask the question that I asked.
Don't argue with me. Ask another question.
Yes, sir. Did you charge the defendant with a misdemeanor? I mean, did you have him arrested for a misdemeanor?
No.
What did you have him arrested for?
Gross and felony.
Why?
I believe that was the correct charge in the first place,
Why?
because I misread the statute.
How so?
As to the type of restraining order.
In what way?
Sorry, I don't understand what you mean what way.
Well, as to the type of restraining order, in what way did you misread it?
I read it as a stalking harassment order.
And you're employed as a detective?
Yes, sir.
Is it your job to investigate?
Yes, sir.
And does that investigation include familiarizing yourself with potential charges and statutes involved in determining if there was a violation to support such charges?
Yes, sir.
Okay. And what did you do in this regard to, with regard to this case to make your determination?
After conferring with the district attorney, the charges were amended.
Okay, but prior to conferring with the district attorney, did you do anything to make sure you charged the right thing and didn't put somebody through a felony and gross charge necessitating $5,000 of bail?
Objection.
Listen,
Listen, that's a ram. Mr. Coughlin, stop it. You're going to get to a point where I tell you to stop it, you're going to stop it, or we're going to cease proceedings. I don't want you to push me to a point where we're having an argument, you're showing disrespect to the court, because we get to a whole different level. You ask him a question. That question was a series of rambling and narrative compound questions. You can ask him a single question, and then that's it.
Yes.
Go ahead.
Did you conduct any investigation or inquiry prior to making the two charges listed on your PC sheet?
Yes, sir.
And what did that consist of?
Documented in our report.
Objection, not responsive.
You ask him a question, he responds to it in a responsive manner, and then you object. It's overruled. His answer was responsive.
What do you mean by documented in my report?
The specific details of my investigation were detailed out in my report.
Okay, well, I'm asking you to testify to those today.
I cannot read you the specifics of my report. I do not recall every word I wrote.
Right. Okay, can you just recall what you remember? Or can you indicate what you remember?
After speaking with Laura Peters, I determined there had been two violations, one for a temporary restraining order violation and one for an extended protection order violation.
And how did you come to that determination?
Evidence, documentation, talking to witnesses.
Such as?
Such as what, sir?
Such as evidence, documentation, and talking to witnesses. What specifically in those three respects did your investigation consist of?
Talking with Ms. Peters, the evidence provided earlier by myself, and the restraining order violations, or the restraining orders themselves.
Objection, not responsive.
Overruled.
What specifically, with respect to talking to Ms. Peters, did you glean from your investigation to support a felony and gross violation of a harassment protection order under NRS 199 rather than?
All right, Mr. Coughlin, once again, you're starting to ramble and ask compound narrative questions. I don't know why you don't listen to what I'm saying. Why don't you ask a question and he'll give you an answer?
What specifically did you learn from Ms. Peters in your investigation to support the charge that you listed on your PC sheet?
That Mr. Coughlin had violated a temporary protection order and an extended protection order.
You learned that from your investigation incident to conferring with Ms. Peters.
And reviewing the documented evidence that she provided, and also the restraining orders that were filed by courts.
Okay. So part of that review would have included looking at what is marked as Exhibit D for the EPO and Exhibit A for the TPO?
I'd have to review those exhibits to make sure, but I believe so.
Would that have also included reviewing Exhibit B, which is essentially just the TPO and Exhibit A?
I'm going to provide to Detective Germany rather, A and B and E and F. These are documents that have been marked and admitted and added to the detective.
Thank you, sir. Yes, those are what I reviewed.
And so, on did you include in your review that the one that's got the Exhibit B that says kind of got a handwritten interlineation proof of service on top of the front page, and then a proof of service by the Justice Court Bailiff English on the last page?
Mm-hmm.
Did you do that because it's necessary as part of your investigation to determine if these orders were served?
Yes, sir.
And if you had determined they weren't served, would you then have pause as to making an arrest or determining a violation had occurred?
Objection, Your Honor. He's asking for the officer, the detective, to speculate. What was
Sustained. Next question. Rephrase your question, Mr. Carter.
Is it necessary to determine if service had taken place of such an order prior to making the determination to arrest?
Yes, sir.
And did you do that in this instance
Yes, sir.
for both the TPO and the EPO?
Yes, sir.
Okay. When were you provided the proof of service in Exhibit B by Bailiff English?
I don't know the exact date.
Was it prior to issuing the determination to make an arrest?
Yes, sir.
Okay. And did you see anything about such purported proof of service that was insufficient that would prevent you from making such an arrest?
No, sir.
Did you see any problems with it whatsoever?
No, sir.
What do you undertake in evaluating whether someone has been served a protection order?
I request proof of service from the courts.
Okay, and if it, for instance, what if they, is there any circumstance in which you get something from the court purporting to be proof of service that you would determine to be lacking something?
I don't know what you mean by something.
Well, something the court purports to be a proof of service of the TPO, and let's say it just had a paw print with ink made on it or something like that.
I don't understand the question.
Okay. If the court, in this instance, had provided you this proof of service, but rather than being filled out with the name Tony English a date, a time, and a signature, but nothing to indicate where the service took place, or whether Mr. English, how old Mr. English was, or whether or not he is or is not a party to the action. If instead of any of that which it contains, it just simply contained like something as though a dog
Mr. Coughlin, you're so far out left field now on your question. I don't understand it. You're beginning to ramble. It's compound and it's not making sense. So why don't you rephrase the question?
Okay. If this proof of service had contained no information other than a paw print, how would have that affected your, like an animal's paw print?
I don't take action off of what animals say or don't say, so I don't understand the question.
Okay, so would it be fair to say in that instance you would determine that there wasn't sufficient service to support an arrest?
I have to have proof of service.
Okay, so at what point do you have it or not have it? What's involved in that analysis?
When it's provided to me by the courts.
Okay, if the court provided you this piece of paper with nothing but a paw print on it,
Mr. Coughlin, that question's been asked and answered. It's irrelevant. We're starting to get to a point with this question on the proof of service that we're going over it and over it and over it. We're beating a dead horse. So ask another question that's relevant that you haven't asked of Detective Iturbi.
yes.
These things are not assisting the court. When you begin to ramble and go on and on, they're of very limited value evidentiary to the court. So go ahead.
Did you notice whether or not there was an indication on this proof of service in, I think it's Exhibit B, as to how old Tony English was?
No, I did not look for a date of birth.
If Mr. English is only 16 years old, would this be?
It's assuming a fact, not an evidence. It says to know. I'm going to disallow that question.
Do you need to determine whether or not someone is over 18 years old in making your determination of whether service has been effective of these protection orders?
That's not determined by me.
What do you mean by that?
I go off.
The answer is responsive.
He said he does not determine. Let me tell you, you're going to get one or two more questions on this proof of service issue, then we're going to move on to a different topic. So I'm limited to two more questions from Detective Iturbi on this issue that is getting very irrelevant to what we're talking about here today.
In your investigation, did you determine in the proof of service where Tony English purports to have served the adverse party, as referenced in Exhibit B?
No.
Why not?
I go off of proof of service. I did not go off of where it is served.
Are you aware of whether or not the sufficiency of proof of service involves listing where the place of service occurred?
Are you asking, I don't know, what the qualification is for service?
Rephrase your question, Mr. Coughlin. I don't understand it. The detective doesn't understand it, so rephrase it.
If there was a checklist for things that needed to be there for proof of service, to be sufficient legally, do you know what would be included on that checklist?
That calls for this witness to speculate. He doesn't have to answer that question. Let's move on to a new topic, Mr. Coughlin. This proof of service issue is becoming irrelevant to the court. So we'll move on to a new topic.
Okay. And, in terms of your qualifications to determine whether or not proof of service is
We're going on to a different topic, Mr. Coughlin. We've exhausted the questioning regarding the proof of service. The detectives who come in here have testified that they made proof of service. They did certain things. Whether it's proof of service will be for the court to consider, not this detective. So ask a different line of questioning. Move on to a different line.
Yes, Your Honor. Did you notice, or you indicated that you had reviewed both Exhibit D, the EPO, and Exhibit A, the TPO. You have those before you now, Detective?
Yes, sir.
Okay. Is there any indication on the first page of either of those in bold lettering, some sort of warning.
Warning for what, sir?
I mean, you know, that's irrelevant. The question, these are exhibits and evidence. I can take judicial note. I don't have to take judicial notice. I can review the terms of those. Detective Yerbody's testimony regarding what is contained in those exhibits now in evidence is irrelevant. That's another question.
Your Honor, if I may make an offer of proof in that regard.
Well, you can make an offer of proof, but try to make an offer of proof instead of rambling.
Yes, sir, Your Honor. Part of the duty of being a peace officer and a prosecutor is that one not put something before this court in a reckless manner, and where that can be proven, or where a defendant in a criminal proceeding under Twombly or Harvey can establish that some misconduct or gross negligence was involved therein. The law provides that such is relevant. Now, where these orders clearly in bold font warn one that a violation is a misdemeanor, and then Detective Utervity, and they're not long orders, Detective Utervity then proceeds to charge the defendant with a gross.
He's testified that he made an error and he made a mistake. I see no error and no evidence of any bad faith or misconduct on behalf of the prosecutor or the police. I've admitted these documents into evidence. They speak for themselves. They're now in evidence to be considered by the court. Move on to a relevant line of questioning.
And I just submit that goes to the weight, not the admissibility.
Move on to a relevant line of questioning.
And if I, just to conclude my offer of proof, if I may, Your Honor, with respect to how that might further support the Hartman and Twombly analysis, is that this arrest occurred 4 days before the trial incident to the Ecom trial, with both Utervity's wife, Jody, and Durrell's wife, Jessica, connected there to, or Durrell testified that February.
Mr. Coughlin, I'm not interested in hearing about this. We're getting so far out in left field again that I'm going to disallow any further. Ask another question, please.
Okay. Were you aware of whether the defendant had a trial days after, within days of this arrest?
No.
Were you aware of whether the defendant had any brief doing a disbarment proceeding?
No.
Within days of this arrest? Okay. At what point was the decision to make an arrest made?
When I filed my PC with my sergeant.
Okay, and why was that determination made? And when did you file that PC? Let's say first.
Based on the evidence that was provided to me, and I would have to look at the PC for the specific date. I don't remember.
Okay. And Your Honor, if I may, what I would hope to have accomplished here is to get accurate copies of both police reports into the record. I appreciate the extent to which you noted earlier, Your Honor, that which I believe to be Exhibit 1 and 2.
I don't understand. What are you saying? What are you asking for?
Well, where Chief Wong was given a substantial amount of time to get his materials in order, maybe Chief Wong could assist in this regard. I just want the police report for 3913 to be in the record, and the police report for 3914.
Wong, did you make copies of those, Mr. Coughlin?
I believe I have copies here. I just had a trial in the Reno Justice Court, which
Do you have copies of those? I don't need to hear any collateral reasons. Do you have a copy of the police report you want admitted? Mr. Wong, do you have a problem with that being admitted if we have it marked?
Your Honor, if he's got copies of something, I'd like to look at them before. I mean, he has the same responsibility to prepare just as I do.
I'm not sure police reports are admissible, but I'll, if you have something you want to mark and have the court take a look at it, I'll do it.
Okay, Your Honor, I think it would just take me a few minutes to find it is the problem. And I've been trying, but I'm kind of...
Do you have a copy, Mr. Wong, so we don't waste any time here?
Your Honor,
So I guess my next question is, how is the police report relevant if Detective Utervity's here to testify? How is that relevant?
I believe it goes to impeach Clerk Peters' testimony as to what she told Detective Utervity and what she...
Well, you can ask Officer Detective Utervity what she said and what she's testified to. I'm not going to admit a police report that you don't have a copy of.
No, I do have a copy of it. I just asked for the same...
Go ahead, next question for Detective Uterby.
I just asked for the same opportunity to find
You
it.
can
if
find
Chief
it,
Wong had
you can find it, go ahead, I'll give you 5, go ahead and take a look. In the meantime, why don't you ask some other questions, Mr. Coughlin?
I don't believe I'll be able to find
Well,
it.
go ahead and ask the questions, so we're not having
to.
Detective Uterby sit there, ask the questions you want to ask him.
Well,
Do
having
you have any
that
other-
police
Do
report.
you have any other questions to ask Detective Uterby?
Yes.
Then ask him.
Okay. So may I look for the police
I
report?
want you to ask him questions. You called him here, we're all sitting here asking some questions.
I understand, Your Honor, but Chief Wong was given a good 10 minutes of silence in this courtroom to go through 100 pages one by one. And
I'll give you 5 minutes to find the police report. That's been provided to you on 2 different occasions, Mr. Coughlin. See if you can find it. Go ahead while we're waiting.
yes, sir. Your Honor, to the extent, if it may expedite matters, I believe that exhibit transcript has a link to what I can indicate to this court as an officer in the court is a complete and true
I'm not
copy.
going to any link in some exhibit that's not been admitted into evidence. Either you're going to find the report you'd like to have marked or you're not. Mr. Wong, are you going to object if we find this report? I mean, what does the report consist of? I'm assuming the city attorney has a copy in the file.
Your Honor, I
Detective
have
Uterby's
in the
report.
file what I believe to be a copy of the report in each
You
case.
say the report, what are we talking about?
Well, and I would say that
I know there's a PC sheet.
arrest report and declaration of probable cause, declarations supplement. Quite frankly, there's a mugshot profile, but I don't know if that's part of the police report. It may be something that my office gets. There's a supplement to original, which I believe is part of the original report. And for the record, I'm talking about 13 CR 03914. There's a report request that Mr. Coughlin done. Quite frankly, I don't know if that's part of the police report.
I'm referring to what Detective Uterby did.
Well, I can't tell you exactly what is in his report. He'd have to tell you. I have a variety of documents that I believe we received from the Reno Police Department as part of his report.
Your Honor, if I could get online, the wireless.
No, Mr. Coughlin, we're not going to, listen, we've been now 6 months into this thing. We're in the middle of trial. Why don't you ask Detective Uterby some further questions, or I'm going to let him read, I'm going to turn it over to cross-examination. Go ahead.
Your Honor, I just note that it seems as though the wireless has been turned
Well,
on.
I'm sorry, but I can't fix the wireless here, Mr. Coughlin. Ask him some questions.
Yes, sir.
there's no further questions, Mr. Coughlin, I'm going to let him go.
No, I have some.
And I want you to ask him right now. I don't want, he's waiting here, he's come back from his job, so go ahead and ask him some questions.
Yes, sir. Did Clerk of Court Peters ever tell you that she was a clerk of court?
I don't remember what her specific job title was.
Did you ever ask her whether there might be some instance or bases in which the defendant here would be permitted to submit, say, documents for filing in the proceeding you referenced earlier?
No.
Why not?
I don't understand why not.
Well, do you just go arrest people real negligently, or do you consider whether or not the law has actually been violated?
Objection argument.
That's odd, this is sustained, Mr. Coughlin. Focus in on some relevant questions, please.
So whether or not he did this negligently is not relevant?
Overruled, sustained, ask another question, Mr. Coughlin.
Do you believe you were negligent in your investigation here?
No.
Why is that?
Because I reviewed the evidence, spoke with Ms. Peters, took the TPO and the EPO violation into consideration, and made my judgment call.
Okay, and so where you charged the wrong statute, which resulted in a $5,000 bail.
Mr. Coughlin, those comments are going to be stricken from the record. He's testified that he considered a different statute, the stalking or harassment. He's testified to that. We're not going to rehash this 6 or 7 times. And quite frankly, in the court's mind, it's irrelevant to the ultimate issue as to whether or not you violated a TPO and or EPO. So move on to your next line of questions.
Yes, sir, Your Honor. With respect to the TPO, was it your understanding that the defendant was prohibited from contacting the State Bar in any way during the pendency of that TPO?
Based upon the regulations of the TPO, yes.
Okay, and so in that Exhibit B of the TPO, can you indicate what portion of that you believe that you made that determination?
Did you say Exhibit E?
B.
Are you asking specifically what portion of the TPO?
Yes.
Yeah, Mr. Coughlin, ultimately, Detective Uturbity's opinion as to whether or not the TPO or EPO was violated is irrelevant. That's, again, you're asking the same question. You're asking for a witness who's not in a position to make the ultimate determination as to whether there's a violation of law. If there was a violation, that's for me. So you're not to answer that. You don't need to answer that question. It's irrelevant.
Your Honor,
It's irrelevant, Mr. Coughlin. I want you to focus on some relevant items that might assist the court instead of sitting in here all afternoon rambling on. I started to wonder if you're talking just to hear yourself talk or you're asking some questions that you think might assist the court or help your case.
Your Honor, it was just where Mr. Wong and Ms. Peters read the title of the filings. I'm merely asking the detective to read it.
It's now in evidence. I can read it. In fact, I've read it after it was admitted into evidence. Having him read it serves no purpose at this point.
During your investigation, Detective Uturbity, did you determine that the TPO provided that the adverse party is, quote, prohibited either directly or through an agent from contacting, intimidating, using, attempting to use, or threatening the use of physical force or otherwise interfering in any way with the employer, the employee of the employee, while the employee is performing his duties, and any person while the person is present in the workplace, including, but not
Mr. Coughlin, wait a minute. I'm going to strike that record. Now you're just reading. You're not asking questions. You're reading documents into the evidence. Ask a question that's relevant, please.
Okay.
Please, help us out and ask some questions that are relevant to your case.
Is it your understanding that the temporary protection order prevented the adverse party from contacting the employer by any means, including by telephone, through the mail, through email, facsimile, or through another person?
Yes, sir.
So is there any other methodology in which one could file a document with the State Bar Court?
You're asking the defendant now to speculate on an irrelevant matter. Ask another question that's relevant. Mr. Coughlin, I remind you that Detective Yerpurvy's role in this case was limited. His testimony this morning on direct examination was very limited. The information he brought to the court was limited. We gave you a great deal of leeway on cross-examination to ask him questions, and your ability to bring a witness in here and just unfetteredly ask questions that are irrelevant reaches a point where there's a limit. And if you don't have any relevant questions anymore, I'm going to let him go. If you want to focus on something you think is relevant or that we haven't gone over 6 or 7 times today, you can do that, but we're not going to sit here and have you ramble on question after question that's irrelevant.
Yes. Did you conduct any investigation to determine any sort of caller ID for the fax or fax ID beyond just looking, as you said, at the fax header?
No, sir.
January 17th fax?
No, sir.
Why not?
That's out of my realm of expertise.
Aren't you a detective?
Yes, sir.
So whose realm of expertise would that fall under?
The computer expert, sir.
Okay, did you refer the matter to a computer expert?
I don't have one.
Okay. Was there any steps taken to determine whether, say, someone else might have faxed that January 17th, 2013 fax?
No, sir.
In hopes of just getting the respondent or the defendant in trouble?
No, sir.
Why not?
I believe the evidence that I had
What?
after reviewing it and speaking with Ms. Peters.
Did it have anything to do with your wife and your role as wife?
Mr. Coughlin, you're not going to go into that line of questioning. I don't know if you have a problem understanding what I'm saying, but you're not going to. I don't want you to ask the police officers any questions about their wives or their families that are absolutely irrelevant. So you're not going to ask another question related to that. Do you understand that?
I did.
Don't go there. They're irrelevant as a matter of law.
Yes, sir. Did the arresting officers point a gun at the defendant's head from 4 feet away when making the arrest?
How's that relevant, Mr. Coughlin? How's that relevant to whether or not you violated a TPO or an EPO?
Well, if someone...
Tell me how it's relevant.
If someone exhibits a number of indicia of vindictiveness, negligence...
And there's been none in this case whatsoever ever raised. None. None. You're speculating. You're throwing things, grabbing things out of the air. I've been reviewing this case for months. I've reviewed every document. There's not an indicia of reliable information that suggests there were any misconduct by the State Bar, by the Reno Police, or by the Reno City Attorney's Office. Ask another relevant question. Ask another relevant question. Mr. Coughlin, move on to some relevant questions. This isn't a fishing expedition that you can engage in here in court today. And I'm not going to allow you to engage in a fishing expedition. That won't happen either.
I understand, but I have an opportunity to put forward impeachment evidence if he...
Ask him impeachment questions that are relevant.
Well, I'd have to have him put on some testimony first that I can impeach.
Ask your next questions. I'm going to put a time limitation on your direct examination of Detective Uturity like I did this morning, because your testimony gets to be, quite frankly, so irrelevant that we begin to put an unnecessary drain on judicial resources. Your questions aren't really helping the court. I'm waiting for you to ask some questions that are helpful about this TPO, and you're just over here just talking to hear yourself. I'm not going to give you any suggestions. I'm telling you the stuff you're asking is irrelevant.
Yes, sir.
I remind you, Detective Uturity played a very limited role in his participation in this case.
So, is it true to say, just to clarify, that clerk of court Peters told you she did not see Coughlin, the defendant, on January 3rd, 2013, in what she believed to be his car or anywhere near the area.
Yes.
So would then your assessment that a violation had occurred sufficient to support a gross misdemeanor arrest be premised upon merely an unidentified man purportedly submitting a document for filing?
Based upon what Ms. Peters told me, yes.
And what was it she told you?
That the documents that were filed on behalf of Zachary Coughlin, and that during the filing, the individual that she described as the male got into the car that she knows is Mr. Coughlin's.
Okay. Was it your determination that that would be tantamount to the adverse party having or contacting the applicant through another person as referenced on page 3, line 4 of the temporary protection order in Exhibit B?
Yes.
Okay. Would that be the case had, or if it wasn't indeed the case, if the adverse party had hired, say, Reno Carson Messenger Service to courier a filing over?
That calls for speculation, so it's a fact, not evidence, so that's, that question is not going to be allowed, it's irrelevant.
Do you know whether the man identified in your police report in reference to you by Clerk Peters was an employee of Reno Carson Messenger Service?
I do not.
Did you make any inquiry in that regard to
No.
determine whether or not he was?
No.
Why not?
I had no evidence on the man except for he was a male.
Did you call the adverse party and ask whether or not he had hired a courier service or some independent contractor to courier a time-sensitive filing to a court in which he had a pending proceeding?
No, sir.
Why not?
I didn't feel the need.
Why not?
Because after reviewing the evidence, I believe that I had cause.
You had cause?
Yes, sir.
But is it probable cause?
Yes, sir.
Okay. Based on what?
The evidence and talking to Ms. Peters and reviewing the restraining orders.
Specifically what evidence?
Okay, Mr. Coughlin, now we're on to this about the 5th time. Detective Uterbity has testified, I've made numerous notes, he spoke to Laura Peters, he reviewed a TPO, he reviewed an EPO, and he made a decision to arrest a probable cause determination. That's all it was. We've asked that, you've established that. Any further questions are of no value to the court at this point. So they're irrelevant. Do you have any questions you want to ask to wrap up the direct examination of Detective Uterbity?
What evidence do you have that the adverse party violated either protection order?
All right. I just went over that. He's testified 3 or 4 times about the evidence he's received. I just outlined it to you 30 seconds ago. It's been testified to. It's asked and answered. Next question.
I'm sorry, I thought we were
Well, no, I don't know how you're sorry. You're not
the
listening to
probable
me.
cause analysis is different than the trial analysis.
I don't need to know what the probable cause analysis was. Detective Uterbity has testified what the information he's received from Laura Peters, the documents he's reviewed, and he's testified 3 or 4 times to that. And you're asking the same question. It's asked and answered. Ask her a new question.
As to the
Ask a new
probable cause
question,
analysis.
please. Ask a new question.
Mischaracterizing what I've done.
No, Mr. Coughlin, you're out here rambling in left field. I want you to ask some relevant questions, or I'm going to cut off. We're going to stop direct examination at some point. You just don't have a right to come in here and ask all these irrelevant questions, sprinkled in with some good questions you've asked her, but this examination comes to an end at some point, and you don't seem to think it does. We're not going to be here till 6 o'clock tonight, so you can sit here and listen to yourself talk.
Did you conduct any further investigation subsequent to the February 8th, 2013 charge in this case?
You mean after the arrest?
Yeah.
No, sir.
Is that typical?
Yes, sir.
In any instances, do you conduct further investigations subsequent to an arrest?
Objection relevance.
What's the relevance, Mr. Coughlin?
Well, there might be some Brady material that was uncovered.
Ask him if there was any Brady material then. Ask the, go ahead and ask what material he provided to Mr. Wong.
Was there any Brady material you uncovered in the course of either your pre or post probable cause investigation?
I provided everything to Chief Wong.
Right. Objection non-responsive.
That's the very responsive. He said he provided everything to the city. The city then has an obligation to provide discovery to you, which is my understanding, having a couple of hearings on this. The city's provided everything to you. And also the court has provided documents to you in March of 2013. I'm setting a quarter till as a deadline, Mr. Coughlin, for a direct examination because the value of this questioning is very, very dubious and does not help the court. So if you have something you'd like to ask that's fresh and new and relevant, please feel free to do that.
Yes, sir. Court's indulgence for a moment, Your Honor.
Mr. Wong, I'm going to return these envelopes to you. I have the documents and evidence. I'll return those to you. I have our detective interpreting. Those exhibits returned to me from Detective Uturby, so we don't misplace any of them. I have a list here. Thank you.
You say you submitted a probable cause declaration to your sergeant?
Yes, sir.
And who was that?
Sergeant McCauley.
Had Sergeant McCauley indicated you had had any previous interactions with the defendant?
Him specifically?
We've gone over this at the very beginning of your direct examination 4 or 5 times. Ask a new line of questioning, or we're going to end up stopping the direct examination, Mr. Coughlin, because you don't have an unfettered right to ask irrelevant questions.
Yes, sir. If I may make a brief offer of proof in that regard. Sergeant McCauley and Officer Gerald here, the wife of...
We're not going into the wives. I'm not going to consider any information you provide regarding the wives of the police officers, Mr. Coughlin. It's not going to be considered by the court.
Respective of pulling me over...
Officer, Mr. Coughlin, ask some relevant questions that would assist the court. We've gone over this. Ask another question, and I'm going to cease the questioning in about 2 or 3 minutes.
Yes.
If you have a fresh, relevant question you want to ask. And if you don't, you don't. At some point, you know, Mr. Coughlin, examination on cross and direct comes to an end. It doesn't go on forever. Sometimes good lawyers know when to stop instead of just rambling on and talking about things that are irrelevant.
Yes, sir.
Is there anything else, Mr. Coughlin, you'd like to ask Detective Turner before I excuse him?
Your Honor, court's indulgence, I'm just trying to determine that real quick.
All right, Officer Duterbury, take your excuse. Thank you very much. Mr. Wong, I'm assuming there's no cross-examination.
Correct.
Thank you, Detective Duterbury. Okay, who do you want to call next, Mr. Coughlin?
Laura Peters.
Is she here yet? Do you know Mr. Wong?
I don't know.
Let's check and see. Thank you, Detective. All right, Laura and Ms. Peters isn't here. We're going to take a 10-minute recess. And one of two things will happen this afternoon. Either she's going to be back here, we have a definitive yes or no. And if not, we're going to continue the case and reset it for the direct examination of Ms. Peters. So it's not anybody's fault. See, if we can't get a hold of her, we can't get a hold of her. And I'm going to give you, Mr. Wong, no one's under any pressure. Let me know in 10 minutes if you've been able to get a hold of her. If not, we're going to simply terminate the proceedings today. We'll bifurcate the trial. We'll finish up. I'll set a date in the very near future to finish up with the testimony of Ms. Peters. So we'll be in recess till that time. No luck, Mr. Wong?
No luck, Your Honor. I did call Ms. Peters' cell phone. The mailbox is still full. I called the State Bar office. The personnel indicated that they would go to the HR department, get her phone number, and call her. They did that and got no answer.
No luck.
They called me back.
All right, well, we'll reset this matter. We'll just bifurcate it. We'll reset it for, let's see, let's do that right now. I want to do this without delay. Mr. Coughlin, do you intend to call any other witnesses besides Ms. Peters? That you know of right now, that's a yes or no?
I'd say possibly Mr. King, maybe Sally Farmer.
Who's she?
I think she's the director of the State Bar, or President Flaherty.
Frank Flaherty is no longer the president
Right.
of the State Bar.
All right, we'll just reset this. Let me just pick some dates. Mr. Wong, you're obviously going to have to get a hold of Ms. Peters, right?
Yes.
So if we set this, well, what about Thursday morning? Wednesday morning? Yeah. We're going to have to, the other, we have what? All right, the other thing we do is I start videos actually, so next week I could do it anytime in the early morning. I'll make sure videos, let's look at next Tuesday, Wednesday, or Thursday. That should give you time to get a hold of Ms. Peters, right, Mr. Wong?
Yes, Your Honor.
Mr. Coughlin, can you do it those days, Tuesday, Wednesday, or Thursday?
I have a trial on Wednesday.
Right, then why don't we plan on doing it Thursday, November 7th?
If it's possible, Your Honor, I'd ask it to move a little bit further around.
No, we're going to get this done right away. You've delayed this long enough. It's been delayed. We're not going to delay it any longer. Let's shoot for then for Tuesday morning.
November 5.
Yeah, let's shoot for
Could
that
we do
day.
the 7th?
I just said the 7th, and you said no.
Well, I asked if we could push out further.
No, I don't want to push it out
Well,
further. I
prefer
want
the
to get it
7th
done.
if possible to the 5th, Your Honor.
All right, then let's go with the 7th. Let's go with the 7th at 9:30. I expected everybody to have all witnesses present. Mr. Wong, anything?
Well, I was just going to say that I think it's appropriate that Mr. Coughlin provide me with a notice of witnesses as required by law.
Yeah, you do that, Mr. Coughlin. You provide Mr. Wong with a notice of any witnesses. You do that ASAP. And I'll try to speed through my videos on Thursday so we can get right to the trial at 9:30.
Yes, sir, Your Honor. Could I get, prior to that time, could I get the audio that
I don't know if we can or not. I can't promise you a thing. We'll do our best.
Okay.
You know, we don't kind of run the court to suit you down here. There's a lot of different concerns going on down here. If we can get it, we can get it. If we can't, we can't.
I don't know if we have any thumb drives.
This, if we can, we can. If we can't, we can't.
To the extent that those thumb drives cost money, I could definitely accept it through email or a SkyDrive link.
It
No,
won't go through email, it's too big.
too big. We're going to give you a thumb drive or a CD.
Okay, Hotmail accounts are free, and they'll accept up to 300.
Thank you. We're not going to do it that way. Thank you very much.
Okay.
All right.
Thursday, November 7th at 9:30 a.m.
Everybody got that, Mr. Wong? Is that clear?
Yes.
That's okay.
Courtroom D. Mr.
Courtroom D.
Coughlin, any misunderstanding about the time and place for trial?
No.
All right, we'll see you back Thursday, November 7th at 9:30. Thank you.
Thank you, Your Honor. I don't believe I got exhibit 2. Do you have 2 copies of exhibit 2?
Please rise. Department 2, Marino Municipal Court is now in session. Honorable Judge William Gardner presiding.
Ladies and gentlemen, have a seat. Mr. Coughlin, Mr. Wong, good morning.
Good morning, Your Honor.
Good morning, Your Honor. Your Honor, is this the microphone that causes a lot of squelching?
Something is, we haven't had the problem here in the last 10 days though, so that's the good news.
Do you want me to turn it on or leave it off?
Turn it,
Leave it off. We're picking up with the.
we're picking it up. Okay, let's see here. For the record, Mr. Coughlin's present, Mr. Wong is present on behalf of the city attorney. This is the time and place for trial in 13 CR 03914. And in this, in 03914, we have an amended criminal complaint on file. I'm going to read into the record that complaint. I, Brian Sudi, Deputy City Attorney, hereby complain that on or about January 17, 2013, at or near 9456 Delaware Boulevard, City of Reno, State of Nevada, the above named defendant, that would be Zachary Coughlin, did violate Nevada Revised Statute 33350, violation of a temporary or extended order for protection against harassment in the workplace, as incorporated to Reno Municipal Code 1.04.015 to wit. The Reno Justice Court issued an extended order for the protection against harassment in the workplace on January 4, 2013, with an expiration date of January 4, 2014. The defendant would serve this order on January 5, 2013. The order prohibited the defendant or an agent of the defendant from contacting the State Bar of Nevada by any means, including facsimile of facts. The complaint further alleges on January 17th, the Nevada State Bar received a 371-page fax with a cover page documented and coming from Zach Coughlin. That charge, Mr. Coughlin has entered a plea not guilty. In case number 13 CR 03913, that criminal complaint reads as follows. I don't believe that would be it. It's an amended criminal complaint filed on March 7, 2013 by Brian Sudi. That alleges that on or about January 3, 2013, at or near 9456 Delaware Boulevard in the city of Reno, State of Nevada, the above named defendant, Zachary Coughlin, that violate Nevada Revised Statute 33.350, violation of the temporary or extended order for protection against harassment in the workplace as incorporated through the Reno Municipal Code 1.04.015 to wit. The Reno Justice Court issued a temporary order for the protection against harassment in the workplace on December 20th, 2012, with an expiration date of January 4th, 2013. The order prohibited the defendant or an agent of the defendant from contacting the Nevada State Bar. The defendant was served this order on December 26, 2012. On January 3rd, 2013, defendant had a male individual contact the location attempting to file documents on behalf of the defendant. To that charge, Mr. Coughlin has entered a plea not guilty. Both matters are now set for trial. Last week on Tuesday, October 22nd, we spent a morning resolving all the pretrial issues with pretrial motions. So, Mr. Long, are you all set?
City's ready to proceed, Your Honor.
And Mr. Coughlin, you ready?
Your Honor, if I may briefly review on that, I believe the court was just reading that for the purpose of addressing the fact that I haven't been arraigned on the amended charges. So at this point, I'd seek a continuance based on the prejudice inherent to that and the ground conditions associated with not being
You've been
arraigned.
arraigned on both charges, Mr. Coughlin. You pled not guilty to both charges, so your motion is denied.
I don't believe it's the amended charges.
The motion is denied. We'll
Yes, sir.
trial this morning. The record is met. Thank you. Go ahead, Mr. Long.
Your Honor, I have 4 witnesses that I'd ask to be sworn all at once.
All
and
right.
then thereafter, I think it would be efficient if I have all the documents marked at once. And then we could.
It's a good idea. All right, why don't we have everybody sworn, and we'll get you sworn in. Go ahead.
The matter stated before this court, you swear your testimony to be the truth, the whole truth, and nothing but the truth. Thank you, sworn.
Okay, what we're going to do, whether or not Mr. Coughlin invokes the rule of exclusion, I'm going to invoke it on behalf of the court to keep the record clean. For those of you, I know, for those of you in law enforcement who probably testified today, I'm going to order those non-testifying witnesses to remain outside in the hallway. Only the witness who will be testifying will be in the courtroom. You're instructed not to discuss any of the testimony in this case with anybody, including yourselves, with the exception of Mr. Long and Mr. Coughlin. That's the rule of exclusion. Are we clear on that? Okay, so have a seat while until Mr. Wong calls his first witness.
Your Honor, if I could quickly
Go ahead.
I had asked this at the outset. If I could file something prior to the start of the trial, I'd ask Marshal Thompson if I could, prior to, I believe, going on the record, just one document I'd hope to file, and that's it.
Well, I entered an order. We've gone over this several times, Mr. Coughlin. Setting trial date and setting deadlines. This case has been pending now for about 6 months. All pretrial motions were to be filed in both cases no later than 5 p.m. on October 10th, 2013. We discussed that at length. What motion now do you intend to file today?
It's just a declaration, sir.
I can go ahead and, did you make a copy for Mr. Wong?
Yes.
I go ahead and you make one for yourself.
Okay, but just to clarify, so this is being filed prior to the start of the trial. It's not waiving my Fifth Amendment rights in any regard or anything like that, is my understanding. Otherwise, I might reconsider that.
Let me see what we got here. Now I'm going to let me go ahead. Did you get a copy, Mr. Wong?
I have not received a copy. I'm just being handed it right now at 9.
I'm not going to disallow the filing of it, but let's go ahead and file it, and I'll take a look at it before we get started. But all pretrial pleadings were to be filed some time ago, so we're good to go.
File stamp.
Okay, you got a file stamp? Let's get that file stamped in.
I would like my copy of file stamp.
Let's get Mr. Long's file stamped in as well. I'm assuming, Mr. Wong and Mr. Coughlin, there's been no pretrial negotiations in this matter. We'll proceed to trial today. Is that correct?
Your Honor, there's been a negotiation offer that was rejected.
That's fine. Mr. Coughlin, there was under no obligation to accept any offers at all, and that will not be held against him as well.
Your Honor, it would be useful, at least from my vantage point, to have a brief opportunity to confer further with Mr. Wong. We did at some length earlier. I don't know that I've rejected resolve.
All right, fair enough. Listen, we waited long enough, given the thousands of pages of motions that I have considered in this case, and given the transfer to this department from another one to me. We're going to take a brief recess to see if Mr. Wong and Mr. Coughlin are able to resolve this matter. I'll remind both counsel that whatever negotiations, if any, that are entered into the court, matters of sentencing are the final discretion with the court. I need not follow any of the recommendations of either parties if there are negotiations made in this case. Does everybody understand? I know you understand that, Mr. Wong.
I understand.
You understand, Mr. Coughlin? I'm not bound by any negotiations you guys may work out. The final, in Nevada, the final say in the sentencing is up to the judge.
Absolutely.
Let's take a 10-minute recess, and let me know if you guys come to a resolution regarding either one of the cases. In the meantime, while I'm up in my office, I'll take a look at Mr. Coughlin's motion. Is actually his declaration that was filed. We'll discuss that as well. We'll recess for 10 minutes.
Thank you, guys. Yeah.
All right, let's go ahead, Mr. Have we reached any negotiations, Mr. Wong, Mr. Coughlin?
No, Your Honor.
All right, let's go ahead and start. Go ahead, Mr. Wong, what you call your first witness. Preliminarily, Mr. Coughlin, I've let you file what appears to be some sort of pleading called a declaration. It's a 10-page pleading. It's typed. It's handwritten at the top with the court caption and City of Reno versus Zachary Coughlin. It appears to be a declaration. All the pages, if not most of the pages, if not all, have writing on the back. I'm assuming those aren't to be considered part of the motion. Is that correct?
That's correct, sir.
All right. The motion appears to be an attack or a discussion or some kind of diatribe about NRS 33-360, the issuance of the injunction by the Justice Court, which references to NRS 33-360, 33-200, references to Judge Pearson in the Justice Court, 33-280, and ultimately this issue has been addressed by Judge Dilworth preliminarily and by me. The Truesdell decision is very clear. 129 Nevada decided April 4th, 2013 that a collateral attack of a TPO is not allowed in the state of Nevada in separate criminal proceedings. That appears to be what this declaration is. I'm ready to file it. It becomes part of the court record, and it will be in the record that we're not entertaining again any attacks in this criminal proceeding, collateral attacks on either one of the restraining orders issued by the judges in the Justice Court. All right.
Your Honor, can I just clarify? Collateral attacks as to whether they're valid or invalid, as opposed to void or voidable?
All of the above. Both.
That wasn't his order.
Right. Thank you. Your motion is denied. Whatever it is, I'm not sure what it is. Have a seat, Mr. Coughlin, Mr. Wong. We're going to get started. So why don't you call your first witness?
Your Honor, I'd ask for permission to pre-mark all of the
Go ahead.
exhibits all at
Get
once.
that done right now. Let's get all the exhibits, and I'm assuming you made copies for Mr. Coughlin.
I have.
Okay.
It'll take me just a few minutes. There are 1, 2, 3, 4, 5, 6 exhibits, and I'll pull the original certified copies, or the certified copies, and Mr. Coughlins' copies. All right, Your Honor, for the record, I have marked documents Exhibit A, B, D, and E.
No C.
I'll comment on that just a moment.
Right.
And the record should reflect that I am handing to Mr. Coughlin copies
I'm
of...
sorry, I'm sorry, I don't mean to interrupt. The rule of exclusion was invoked, Your Honor. It would be appropriate this time to ask that
That'll happen once we start the witnesses testifying. As soon as that happens, Mr. Coughlin, I will invoke that rule. Please.
The record should reflect that I'm handing copies of Exhibit A, B, D, and E to Mr. Coughlin.
Okay.
Your Honor, with regard to Exhibits C and F, they are documents that Detective Iturbide have brought from the evidence section, and when he takes a stand, I'll have the Exhibit C and Exhibit F marked. I had him bring the documents evidence so we didn't get into issues about duplicate originals. They are the documents that are in evidence, and when I have C and F marked, I do have copies of Exhibit C and Exhibit F for Mr. Coughlin.
All right, are you ready to call your first witness?
Yes, my first witness, are you ready, Your Honor?
Yes, I am.
My first witness would be Tony English.
All right, the rule and vote of Mr. Officer English, come on up. You have been sworn. The other witnesses are admonished to wait in the hallway. Do not discuss your testimony with anybody pending the final resolution of this matter. Thank you. And we've had the witnesses sworn.
Yes, sir.
Correct. Your other oath, Officer English. Good morning. All right. Go ahead, Mr. Wong.
Sir, would you please state your full name and spell your last name for the record?
Anthony English, English.
What was your profession or occupation on December 26, 2012?
Bailiff for Reno Justice Court.
Were you working on December 26, 2012 at approximately 2:58 p.m.?
I was.
Do you know the defendant, Zachary Coughlin?
I do.
Do you see him in the courtroom here today?
I do.
Would you please point him out and describe the clothing that he's wearing in courtroom today?
I'm wearing a dark blue jacket, light blue shirt.
Your Honor, would the record reflect the identification of Mr. Coughlin?
Seated at the council table?
Yes.
The record will reflect the identification of Mr. Coughlin.
Mr. English, were you over the age of 18 on December 26, 2012?
I was.
Objection, Your Honor. If I can move for standby counsel.
No, it's denied. You've had plenty of time, Mr. Coughlin, to find that's a meritless, frivolous request, and it's denied. Go ahead, Mr. Wong. Denied.
Yes, sir.
Let's see.
Just can't
Go ahead.
basis on the record for it.
Go ahead.
Mr. English, let me hand to you what has been marked as Plaintiff's Exhibit A and Plaintiff's Exhibit B. Would you please look at those to yourself? And when you're done looking at them, please look up at me.
And I'll just make an objection based on relevancy.
Well, I think you've been offered it to put him into evidence yet, have they?
No, just on the testimony of Bailiff English. He's not amongst those members of any of those law enforcement entities listed as ordered to serve the temporary protection order.
Denied. Go ahead, Mr. Wong.
Have you finished looking at City's Exhibit A and B?
I have.
Do you recognize those documents?
I do.
Mr. English, on December 26, 2012, were you a party to the Reno Justice Court case that's identified in Exhibit A and B?
No.
The objection calls for a legal conclusion.
Overruled. Go ahead, Mr. Wong.
Directing your attention to Plaintiff's Exhibit A, what, if anything, did you do with a copy of that document with Mr. Coughlin on December 26, 2012?
I served him this document.
Would you please look at Exhibit B? And what is Exhibit B?
It's a proof of service of
I can't hear it. I'm sitting right here.
the, sorry, proof of service of the temporary protection order.
On Mr. Coughlin?
Yes.
Is there any type of certification on Exhibit A and or, well, let's one at a time. Is there any type of certification on Exhibit A?
Yes, there's a stamp. Justice Pete's County stamp.
Okay. Is there any type of certification on Exhibit B?
Objection calls for a legal conclusion.
Overruled.
I filled out the proof of service upon adverse party, and it was filed stamped in the court.
And direct your attention to the last page on the lower left-hand corner. What am I pointing at?
Which exhibit?
I'm sorry, Exhibit B. Last page, bottom left-hand corner of Exhibit B.
It's a certification
I
stamp.
can't hear you. I'm sitting right here. So I'm asking you, remember, you're addressing the court and the record, so I just need to have you speak up. Thank you.
It's a certification of Justice Peace.
Your Honor, I move for admission of Exhibit A and B.
Mr. Coughlin, any objection? Okay,
Yes,
let's talk about A first.
Yes, Your Honor. Jake? I can't tell who the clerk of court is on this certification.
Is that on Exhibit A?
Yes, sir. In terms of on page 5, whose signature that is, there's no sort of textual reference underneath the signature on the line.
Is that the basis for your objection?
That's one.
What else?
That it's an incomplete document and that it lacks a proof of service where the Reno Justice Court returns to me documents should I not include a proof of service.
Mr. Wong, you want to respond to those objections?
Well, as an officer of the court, I will tell you that Exhibit A is a certified copy of the order. And
Which order?
of the temporary protection. And Exhibit B is the proof of service.
And that's the order from the Reno Justice Court that's
Correct.
the basis for the criminal complaints in this case?
Yes. Is the proof of service. It's a memorialization of Mr. English serving Exhibit A on the defendant. There is nothing in the statute. He complains about no evidence of a return. There is no requirement in the statute that there be a return. And I'm not exactly sure what he means by return, but there's no requirement of a return. There is, again, the proof of service is Exhibit B, it's a certified copy of the court record, and it establishes that he was in fact served.
Okay, Mr. Coughlin, you have any objection to Exhibit B?
Yes, Your Honor. Similarly, Exhibit B on, I believe it's page 5 again, contains what what Chief Wong purports to be a certified copy or some sort of certification. However, one must be authorized to make a certification in order to determine whether or not the person so signing this is authorized. I would need to know their name and their position within the Reno Justice Court, including whether or not they fall within the purview of the deputy clerk under NRS 4.353 sub 6, I believe it is. So to that extent I object, because I have no idea whose signature that is and whether or not they are one who is authorized or indeed able to provide such a certification. Beyond that, it does not seem as though Exhibit B has a file stamp that's on this first page that's any different than the file stamp of Exhibit A, whereas Exhibit A is file stamp 2:51 p.m. and Bailiff English's proof of service lists 14:58 hours as the time of service.
Mr. Wong, we take a look at both A and B, cities A and B. Plaintiff's Exhibit A is a file stamped certified copy of a temporary order for protection against harassment in the workplace, signed by one of the judges on December 20th, 2012. Exhibit A is admitted into evidence. Plaintiff's Exhibit B, file stamped copy of a temporary. Now what I have here is, the proof of service of a temporary order for protection against harassment in the workplace. Indicated that Deputy Tony English, or officer or deputy? Bailiff English had served proof of the same. Exhibit B is the exact same document as Exhibit A, with the notation on the page 5 that Bailiff English had served the temporary order of protection against harassment in the workplace. Both of these are in case number RCP 2012607, so Exhibit B is also admitted in part of the court record. Go ahead, Mr. Wong.
Thank you, Your Honor, and I would also direct the court's attention to the file stamp on the last page, lower right-hand corner of Exhibit B, establishing a filing of the proof of service on December 26, 2012 at 4:34 p.m.
That comment is noted for the record and clearly reflected on page 5 of the Plaintiff's Exhibit B, City's Exhibit B. Okay.
Your Honor, just briefly in that regard, I object to the extent that I believe file stamps are to be placed on the front page of the filings.
And of course, in response to that, Plaintiff's Exhibit B contains both the file stamp of December 20th and December 26th on Exhibit B. Page 1, December 20th file stamped. Page 5, December 26th file stamped. So those items just simply speak for themselves. Mr. Wong?
A and B are admitted, Your Honor.
Yes, they are. A and B are both admitted into evidence over objection of Mr. Coughlin to both exhibits.
Your Honor, if I may lastly make one more quick, I guess it would be objection to the record. To the extent that Exhibit B has an interlineation at top, page 1, there are proof of service, and it's just this sort of thing that I've been purported to have done myself, which has resulted in rejections of my filings in both this and in the Reno Justice Court. More so, I believe, in the Reno Justice Court, where it's, I guess, an allegation, if you will. I've taken past filings and somehow altered them and refiled them, or I don't know to what extent any fraud is being alleged. It's more of this is confusing type thing, so I just make that check.
All right, that's noted. By the way, that goes to the weight of the admissibility, not to the admissibility, the weight of the document, not to the admissibility. I will note, Mr. Coughlin, that as a judge, I've admitted I've allowed every single filing you've made in this court, which are replete with thousands of, not thousands, but numerous delineations by you. I've allowed those to be filed. This simply on Exhibit B says proof of service. Your objection is noted for the record. All right, go ahead, Mr. Wong.
Your Honor, I have no additional questions.
All right.
Mr. English.
Mr. Coughlin, cross-examination of Bailiff English.
Good morning, Bailiff English. Were you elected to your position as bailiff?
I was not.
Were you appointed?
Your Honor, I ask the witness to get closer to the microphone.
I'd like both Mr. Coughlin and Bailiff English to both speak up. It's not the microphone that's prohibiting us from hearing. It's just we need to have you speak up, both of you, loudly and clearly. So, Mr. Coughlin, on your questions, loudly and clearly. Bailiff English, stay, please. Thank you.
Yes, sir. Were you Bailiff English? Were you appointed to your position as a bailiff?
I don't believe so.
Were you deputized?
Not at Reno Justice Court.
In any manner connected with Reno Justice Court, have you been deputized?
No, don't believe so.
When you indicate not at Reno Justice Court, is that indicative that at some point in your career you were deputized within another law enforcement capacity?
Correct.
So you understand that you're an employee of the Reno Justice Court?
Yes.
Has any judge ever, with the Reno Justice Court, ever indicated to you that you're a deputy clerk?
No.
Has any judge there ever indicated you're a deputy marshal or city marshal in any
No.
way? Okay. What brought about your purporting to serve this document in Exhibit B for a?
Not really sure what brought it about. I knew you needed to be served some orders. Knew you had an appointment that day and were going to be at the Department of Alternative Sentencing Office.
How did you know these things?
Personal knowledge, I don't remember exactly how. I knew.
Personal knowledge gleaned from your capacity as an employee of the Reno Justice Court, or?
Yes.
Okay. Were you directed by anyone to serve, purportedly serve this document?
My supervisor,
And who would that be?
Mike Sexton.
And can you indicate as nearly as you recall what his directions to you were in any statements in connection therewith?
I don't recall exact statements.
Did he make any statements to the effect that he was aware, and I'll probably refer to myself as the defendant or Mr. Coughlin, just so you don't get confused or think I'm too weird talking to the third person, but for the purposes of the record. Did he make any indication that he was aware of Mr. Coughlin? The Chief Bailiff says so. Did he make any indication that he was aware Mr. Coughlin would be visiting the Department of Alternative Sentencing on that day? I believe it was a Wednesday.
I don't recall if he had that information or if I knew that information.
Is it fair to say that your testimony is that you utilized that information to plan for an opportunity to attempt service of this document on Mr. Coughlin?
Yes.
Had you read the document prior to serving it?
I don't believe I read it the entirety.
Did you look at it?
Just cover sheet, yes.
Cover sheet, yes, is that what you said?
Yes.
And by cover sheet, do you mean the first page with the file stamp?
Yes.
Where did you get the document?
I don't recall exactly. I believe Mike Sexton gave me the document.
But you don't recall? So
No.
it could have come from somewhere else.
Potentially.
Could have come from somebody who just made it up, for all you know.
I don't know.
You don't know who it came from, or you don't know whether it's possible that it came from somebody.
I know it was certified by the court.
How do you know that?
The date stamp and the cert stamp.
The cert stamp? So is it your testimony that at the time of your purported service of Exhibit A is this what you're referring to as the cert stamp on page 5?
Yes.
That was located thereon?
I can't for sure on that cert stamp, no, actually. But the file stamp, yes.
Did on your certificate of service, did you, on Exhibit B on page 5, there's what appears to be an interlineation and pin indicating, I believe, cert by bailiff. Did you write that?
I did not.
Was that written before you signed this?
No, I don't believe so. I don't recall.
So, is it your testimony that you believe the interlineation cert by bailiff was written after you had filled out and signed this proof of service upon the first party?
I believe so.
Your Honor, I moved out this document stricken to the extent it's been altered after bailiff English has attested, signed his name. Well, I don't know if there's a declaration attached to that. But to the extent bailiff English is apparently testifying that it's been altered prior to or subsequent to his signing it.
Well, the record speaks for itself. There's a notation that says served by bailiff on page 5. That doesn't provide a legal basis to strike the document, so your request is denied.
Yes, sir. Bailiff English, when you filled out this proof of service upon the adverse party, did you thereafter take it to be filed?
Yes.
And who filed it?
I don't recall.
But is it fair to say that you don't yourself affix a file stamp to the document?
Generally, no.
Okay.
Your Honor, I've given Mr. Coughlin some leeway in his cross-examination. I would argue that this entire series of questions go to the validity of the TPO. We have a law of the case that says there cannot be a collateral attack on the underlying TPO, and so I would object to any additional further questions.
In Your Honor, I'd just briefly respond that I believe one might characterize this line of questioning as rather going to the sufficiency of service of the TPO rather than the validity of the order in and of itself. I think those are distinct legal issues, but I recognize that this line of questioning likely needs to pick up the pace to some extent.
Yeah, I'm going to overrule Mr. Wong's objection. I want to limit you. We're not going to spend all day on this cross-examination. You certainly can ask any questions that go directly to what Bailiff English raised in his direct examination was he served Exhibit A at Longview, and there's some questions regarding that, but you're right, at some point we get far afield of what he's testified to, and the question becomes, in the court's mind, irrelevant and unnecessary. So limit your focus, Mr. Coughlin, to the service and see if you can wrap up the cross-examination related to that issue.
Yes, sir. I'm anticipating approximately 3 to 4 more questions here, if that's permissible. Bailiff English, did you interlineate on page 1 of Exhibit B at the top, that exhibit appears to be proof of service?
I did not.
And I'll just note for the record, at least on my copy, I'm guessing that that same proof of service, it has 2 hole punches, which
Does the original has hole punches to the proof of service on plaintiff's Exhibit B?
Bailiff English, at the time of your purported service of Exhibit A, can you describe the level of awareness the party you were purporting to serve had of your purported service?
Level. When you came in, you saw me approaching you with paperwork. You said, "I'm not here to be served." Put your fingers in your ears and walk to the Department of Alternative Sentencing.
And where was the defendant at that time? Was he within the Arena Justice Court Department of Alternative Sentencing Horseshoe, I believe it's called?
You were in the horseshoe
Okay.
within the office of the Department of Alternative Sentencing.
So the purported actual act of handing the Exhibit A to the defendant occurred within the Department of Alternative Sentencing's, I guess, room, you might call it?
Correct.
Okay. Was there any force applied to prevent the defendant from exiting the room in any manner?
No.
Was the defendant face-to-face with you?
At times.
Can you describe why you qualify that?
Well, with your fingers in your ear, you were facing away from me, facing the wall.
Okay. And so did you drop these documents you referenced, or?
In the first occasion while you were facing the wall with your fingers in your ear, I put the document in front of your face, explained to you that you'd been served. And then I put the documents on the counter and stood by the office, at which point, with your fingers still in your ear, you were just answering questions with the Department of Alternative Sentencing civilian worker, at which point I determined that since you were answering her questions with your fingers in your ear, you could now hear me. So once again, I held up the paperwork and said you have been served.
And did the defendant say anything further at that time?
I don't recall exactly what you said.
Did the defendant say anything to the effect of, just 1 second, sir, please wait your turn, I'm almost done checking in?
I don't recall what you said, actually.
Okay. Has any Justice of the Peace with the Arena Justice Court ever directed you to serve documents?
At this point, I'm going to sustain the objection. We're starting to get far afield with the issue of proof of service again on you, and I want to limit your inquiry to that. Quite frankly, I'm not sure what else you can add to this line of questioning that you haven't already accomplished.
Yes, sir. Thank you.
Mr. Wong, any redirect?
No redirect.
All right, Bailiff English, you can take a seat in the hallway unless you wanted to return.
You know, he works at Renal Justice Court. I'd ask that be excused, go back to work, and if we need him, then we can.
Play back. Remind you that notwithstanding the fact you're going back to work, remember the rule of exclusion, don't discuss this case with anybody over there, any of the witnesses who testified to this matter's resolved. So very important that that not happen.
Yes.
Thank you very much.
Thank you.
Your Honor, my next witness would be Clint Flair.
Your Honor, if I can just quickly seek clarification from the court with respect to, is this both trials are occurring simultaneously, or is it one after the
You're
other?
having a trial on both cases, yes.
At the same time?
Yes.
Okay. and I just make my objection to that for the record.
Your objection has been noted several times for the record. Your objections have been overruled, and it's noted for the record. All right.
And, Your Honor, just
Jesse, good morning.
to clarify, my misunderstanding was, I understood they were both being held today, I just didn't know if it was going to be one.
Same time. Yep. We're all going to do all this right now. So go ahead, Mr. Wong.
Sir, would you, and please speak aloud and clearly into the microphone because this is being recorded. Do you understand that?
Yes.
Would you please state your full name and spell your last name for the record?
Clint Player, Player.
Sir, what is your profession or occupation on January 5, 2013?
Deputy Sheriff, Washington County Sheriff's Office, assigned to the Civil Division.
Were you over the age of 18 on January 5, 2013?
Yes.
Let me hand you what has been marked as Plans Exhibit D and E. Would you please look at them entirely to yourself, and then when you're done, please look up.
Okay.
Do you recognize those documents?
Yes.
Okay. And for the record, they're court documents involving a particular case. On January 5, 2013, were you a party to the case that's identified in those two documents?
No, I was not.
Were you working on January 5, 2013 at approximately 10 a.m.?
Yes, I was.
Can you please tell the court where you were on that date at that time, approximately?
At Zachary Coughlin's house, located on East 9th Street.
Do you know Zachary Coughlin?
I know of him.
Okay. Do you see him in courtroom here today?
Yes, I do.
Would you please point him out and describe the clothing that he's wearing today?
Yes. Sitting to my right, green glasses, blue suit, blue shirt, tie.
Record of identification, Mr. Coughlin.
Directing your attention to City's Exhibit D, did you serve that document on Mr. Coughlin on January 5, 2013 at approximately 10 a.m.?
Yes, I did.
And directing your
What date was that?
January 5, 2013 at 10 a.m. Was that the correct date and time?
Yes, it was.
Okay, would you please look at it, your City's Exhibit E, and what is that?
Affidavit of service.
Who filled it out?
I did.
And why did you do that?
To document the service of the extended protection order.
And the date and time set forth in the affidavit of service is what?
January 5th, 2013, 10 a.m.
Your Honor, I move for admission Exhibit D and E.
Any objection, Mr. Coughlin?
Yes, Your Honor, similar to the objections earlier with Exhibit
Can I, before I let me interrupt, let me get the copies though, so we're making an objection. I can make it read. All right, thank you. All right, go ahead, Mr. Coughlin.
Similar to the objection earlier with A and B, Your Honor, the purported certification on page 4 of D lacks a indication of whose signature that is, or whether such person is able to so provide such a certification.
You're talking on page 4 that says the signature on, where it says judge, or where on the certified stamp? Which one?
Both, actually, Your Honor. That's something further I'd like to object to the extent that there's no indication of which judge signed that, other than what appears to be a signature. Likewise with the Exhibit E, similarly on page 101, there's no indication of which, who that is, or it says Steve Tuttle, Clerk, Reno Justice Court, but the signature does not look like Mr. Tuttle's.
Are you talking about the file stamp part?
No.
There's numerous signatures on there. There's a notary public, there's a certification stamp, there's a sheriff's authorized agent, that, which appears to be Deputy Player, who's testified that is his signature, is badge number 2591, and there's a file stamp notation in the right corner. What are you talking about?
I'm speaking of the, it looks like some sort of seal that's been fixed in the lower left part of the page. Along with that, what looks like a manual stamping, it says Steve Tuttle, clerk, Marina Justice Court. However, there's a signature line, someone's signature who I do not recognize to be Mr. Tuttle's. From my own.
It says it's a deputy clerk under there with the court. Deputy clerk appears
Yes,
to be
sir.
there, appears to be Marilyn Miller's signature.
Well, I object to any extrajudicial knowledge of clerks' names or the look at their signature being.
No extrajudicial knowledge. I don't know who she is. It just simply says Marilyn Miller, deputy court clerk. That's what it says.
I don't know that, and I think one would
Is that the
take
basis?
testimony.
Is that the basis for your objection of D&E? Is that some of the signatures you don't know who they are?
I can't read them. They don't have a typed or even printed indication of whose signature that belongs to. So yes, sir.
If it's D&E, you're both admitted. Exhibit D is a certified copy of the extended order for protection against harassment in the workplace. Case number RCP 2012-607, signed by a judge of the court, certified by a deputy clerk of the court. Plaintiff's exhibit
Your Honor.
E is a certified copy of a affidavit of service. Deputy Player has testified that not only did he serve you with exhibit D, but that's his signature on plaintiff's E, so both are admitted.
Your Honor, may I make one last objection to that? To the extent that this affidavit of service, wherein it, in the middle of the page references the documents served were, extended order of protection against harassment in the workplace, fails to indicate which case within such extended order issues from. So to that extent, I object based on relevancy, and that's it.
All right, your objection goes to the weight of the evidence, not to the admissibility. So D and E are both admitted and become part of the court record. Mr. Wong, any further questions of Deputy Player?
No.
Cross-examination of Deputy Player related to the issue of service, Mr. Coughlin.
Yes, sir. Good morning, Deputy Player. Were you elected to your position as a deputy sheriff? I believe it. I have that right?
Yes,
You were elected to that position?
not elected.
Were you appointed?
No,
You did reference that you're a deputy, though. Is that correct?
yes,
Is it fair to say you've been deputized?
yes.
And when did that occur? And who was involved with that?
That was in 2001, and that was through the sheriff's office.
Do you recall who? Was there a ceremony or something in that regard?
Yes, Sheriff Dennis Whelan.
Mr. Balin being the sheriff, or
Yes,
not Mr. Haley or Sheriff Haley?
no,
Okay. Is it your understanding that you're an employee with the Washington County Sheriff's Office?
yes,
Okay. Not a public officer?
sheriff's office.
I understand you work at the sheriff's office, but it's your understanding that you're an employee rather than a public officer. Is that correct?
I am an employee.
Okay. Did the defendant here that you purport to have served Exhibit A indicate resist in any way to your so serving or purportedly attempting to serve?
Yes,
Can you describe that?
yes, I made contact with Mr. Zachary in front of his residence.
You mean Mr. Coughlin?
Officer
Zachary
Zachary Coughlin.
Okay.
And as I pulled out the paperwork, he immediately put his hands up to his ears and started repeating, "I cannot hear you, I cannot hear you." I made several attempts to explain to him that he was not being detained. I was just there to serve paperwork, simple paperwork, to give him his copy of the extended protection order. Coughlin made the statement he would like to go to his residence and proceeded to walk towards his front door. I again tried to hand him the paperwork, and at which point he began to say, "I cannot hear you." I placed the paperwork on the tail section of his vehicle and said, "This is your paperwork, you have been served." As I was walking away, Mr. Coughlin said, "You have forgot your paperwork," and pointed to the paperwork. I informed him again that it was his paperwork and it was an extended protection order, and asked if he had any questions. I returned to my vehicle along with Deputy Courtney, who was with me the entire time. We witnessed Coughlin grab the paperwork from his vehicle and began to look at it. I pulled up in my vehicle to Coughlin again and advised him that I was glad to see he had received his paperwork and that he was served.
Okay. And was this on Saturday?
I do not recall it.
I asked that the record reflect that January 5th is Saturday of 2013. It's a Saturday.
I don't know whether that's a Saturday or not. I don't, if it's a Saturday, it's a Saturday. If it's not, it's not.
Okay. You referenced placing some documents on the defendant's vehicle. Was the vehicle located on what you believe to be the defendant's property, or?
Yes, it was in the driveway.
So you stepped foot onto the property?
Yes, I had spoken with another roommate who had access to the property, who allowed me on the property prior to that.
And who was that?
I did not recall his name at this time, but it is in a report I made.
Okay. Do you have a copy of that report?
I do in the hallway.
Okay. Did you place your hands on the defendant at any point in
I did not.
this interaction? Did you reference one other member of the sheriff's office there?
Deputy Courtney was with me.
Did he?
He did not. He had put his hand up as you were walking by, and you ran into his hand.
That's Deputy Courtney?
Courtney. Yes.
And you indicate the defendant ran into Deputy Courtney's hand?
Yes.
Where was Deputy Courtney's hand positioned? Was it in front of his body, off to the side, or
Directly in front of him.
directly in front of him?
Yes.
So is the defendant walking into Deputy Courtney, would you say?
Yes.
Did the defendant make any attempt to walk around Deputy Courtney?
No, he walked directly towards you.
Wouldn't that normally result in some sort of arrest for resisting public officer somehow?
No.
No? So did the defendant continue walking, you say, through Deputy Courtney?
He did step to the side and walk past.
And did Deputy Courtney move his arm in any way to continue contacting the defendant?
No.
Is it unusual for you to work on a Saturday?
No.
Is it unusual for documents to be attempted service of such documents to occur on a Saturday?
No.
How did you come into possession of this document and Exhibit A?
We have a stack of temporary protection orders that we have to serve, and in that stack, that order was in there. I don't recall exactly when I picked it up or whom I picked it up from. But you recall, the day beforehand, I had attempted to serve it at your residence with no result.
The date prior, on January 4th, you had attempted to serve?
Yes.
Okay. And are these documents that are faxed from the Reno Justice Court to the Sheriff's Office to be served?
Yes.
So they're faxed?
I do not know if it was faxed or
Okay. Do you ever serve or carry out eviction orders?
yes, I do.
Do you post those on a door and wait 24 hours prior to effecting a lockout?
We do not do the posting. We actually serve the eviction.
And how is that conducted?
Your objection relevance
That's
on
not
the record.
relevant to what happened in this case. So that's, move on to the different line of questioning, Mr. Kaufman, related to the service of B of Exhibit D on you.
Yes.
That's the focus of your inquiry. So with that,
Was there any consideration of charging the defendant here with resisting a public officer in connection with any of the interaction related to this purported service?
Objection relevant.
It's irrelevant to say.
I think that's all I have. Oh, just a couple more quick questions, Your Honor. Is there some policy or statute or rule that you're aware of with respect to how soon you must file a proof of service or your affidavit of service, such as in Exhibit E after having effected service?
We usually try to file it within the same day or within 24 hours.
And was that done in this case?
I believe it wasn't notarized until the following Monday because there was no office personnel.
Okay, so where January 5th would have been a Saturday, the Monday would have been January 7th,
Yes, sir.
and this affidavit of service is file stamped January 14th?
I don't have a copy of it in front of me.
If I may approach Your Honor or have judicial notice.
Actually, there's an Exhibit D here. Why don't you hand it, that came with the original. I believe that's just a copy. You can hand that to the deputy. Please.
Thank you.
Do you see where that Exhibit E, your affidavit of service?
I'm sorry, I have Exhibit D here.
I'm sorry,
E,
Exhibit D is right here. I'm sorry. Here's the originals, D and E, for delivery to deputy. Right.
And I think what you handed to Deputy Clare is actually my
All right,
copy.
why don't you take that back? It's certainly not a copy that the court has been marked and admitted as evidence. So, Deputy Clare, take a look at what was been marked D and E for your information.
And it looks as if it was notarized on the 7th.
Okay, and your testimony is that the purported service took place on January 5th.
Yes, sir.
And so thereafter it was filed. Do you see where the file stamp on Exhibit E in the upper right-hand corner indicates the date of January 14th?
Yes, sir.
Is it your understanding that your office is under an obligation to get such affidavits of service for protection orders such as the one in question here filed sooner than it's like 9 calendar days after?
I do not know what the policy is on having it filed within the court system.
Okay. I think that's all I have, Your Honor.
All right, thank you, Mr. Coughlin. Mr. Wong, any redirect?
No, Your Honor.
All right, Deputy Player, thank you very much. I'll remind you, during the course and scope of while this trial is pending, that you have no discussion with this case in any manner, anybody, save and except Mr. Wong or Mr. Coughlin, or unless I order otherwise. So if you leave today and head back to work, just make sure you don't discuss the case with anybody related to any aspect of your testimony, okay? Thank you.
Or may I just have a moment with Mr. Clare to get his phone number in case we need help? Your Honor, my next witness is Tom Eturbide. Okay.
Eturbide, good morning. You take the stand. Remind you that you're under oath.
Yes, sir. Excuse me.
Where are you ready, Mr. Wong?
Sir, would you please state your full name and spell your last name for the record?
Thomas Michael Iturbide III. It's Yturbide.
What is your professional occupation?
I'm a detective with the Reno Police Department.
Were you assigned a case involving the defendant Zachary Kaufman?
Yes, sir.
Did you bring some items of evidence from Reno Police Department evidence with you to court today?
Yes, sir.
Your Honor, this is the Exhibit C and F. Well, first of all, Are they in sealed envelopes?
Yes.
Are they still sealed?
Yes.
Okay. So, Your Honor, what I'd ask is that Mr. Turbide open them and then show them to me, and then I'm going to have to compare what I believe them to be with the evidence, and then if they are what I believe them to be, I do have copies of them for Mr. Kaufman.
Okay, go ahead, Detective Turby.
You don't perhaps have a letter opener, do you?
We'll get one for you. Somebody's got one in here. Here you go.
So let's not get, for the record to reflect, there are two envelopes. I'm going to ask Mr. Turbide not to get them mixed up. And
The first paper bag envelope is for case 13-100306.
would you please pull out the item? Your Honor, for the record, I'm going to take the item, I'm going to mark it plaintiff's exhibits.
Your Honor, if I can just invoke the rule of disclosure to the extent that I don't know if it's part of the order, but Bailiff Sexton.
I don't believe Bailiff Sexton's going to be testifying, or is that correct, Bailiff Sexton?
That's correct.
So he's certainly free to be here in court.
You don't know that he's the
He
one.
won't be testifying if he's sitting in here in court. I invoked the rule, so if he's, all witnesses who will be testifying are outside the courtroom. So if Mr. Wong calls him, I'm not going to let him testify.
Well, I might call Bailiff Sexton. Because my understanding, he left the room, that everyone left the room.
If you provide him and your list of witnesses to Mr. Wong, that you're going to be calling Bailiff Sexton?
No, Your Honor.
Do you think you're going to be calling Bailiff Sexton?
It's possible.
Right, Bailiff Sexton, fair enough. If Mr. Coughlin has the personal intent to call you, if you have any relevant information, I'll also ask you to sit outside and not discuss the testimony. Yes, sir. Thank you, sir. All right.
Your Honor, record to reflect that the item that Mr. Turbide pulled out, I'm going to affix plaintiff's exhibit C sticker to it. And it is multiple pages, Your Honor. I'd like just a few moments to compare it to my copies.
Go ahead.
For the record, Your Honor, it appears to be 100 pages, so it'll take me just a few moments.
Go ahead.
Your Honor, I'm not sure if Chief Wong has sought introduction of this at this point, but to the extent he has, I guess, that I be provided a copy.
Oh, you'll get a copy. No, he hasn't yet had it. He's had it marked, and he's not asked it to be admitted, but you will get an opportunity to review that, of course.
Thank you. Your Honor, I'd object to the extent the court has apparently just made copies for the city attorney. 2 copies of them seem being handed to the city attorney. I don't believe that's appropriate at all.
Yeah, you have to make copies for the levels before.
Nothing inappropriate about making copies for you. We made copies for you last time we were in court. What copies did we just deliver to Mr. Long?
I don't know.
Want to make,
Can we just
all right.
ask you to make copies?
We'll make copies for you too, Mr. Coughlin, if you need any.
I understand, Your Honor, and I don't mean any disrespect in that regard or to imply. I did not request copies to be made last time, though. I do not believe.
The fact we made some copies for the parties in court is not a basis to object to anything. Those have not been offered to be in evidence yet. So, it's the appropriate time you can make any objections. If you need copies of anything you need, Mr. Coughlin, let us know. We'll get some for you too.
Your Honor, thank you for your indulgence. For the record, I have compared what I put Plaintiff's Exhibit C stamp on that Mr. Turbide pulled out from his evidence folder with the copy of Exhibit C I have prepared for Mr. Coughlin. They are exactly the same except for the CD that is attached. And the records reflect I am handing Mr. Coughlin the exact copy of the pages of Exhibit C. The record should also reflect that on or about July 2nd, 2013, you should have in the court's file a discovery, and with that document, you have a copy of the document, but with the original of that discovery, we served Mr. Coughlin with a CD that is similar to the CD that is attached to Plaintiff's Exhibit C.
Your Honor, I object. I've not been given a copy of this document.
Given one this morning, Mr. Wong says that you've previously been served a copy of what's contained in that document in a CD. What is the document, Mr. Wong?
Your Honor, it's the documents that we allege Mr. Coughlin's agent delivered to the State Bar on January 3rd, 2013. I will state for the record that all items of evidence that are being marked and hopefully admitted into evidence here today have been previously provided to Mr. Coughlin. And again, on July 2nd, 2013, we did provide him with a CD similar to the CD that's attached to what's been marked Plaintiff's Exhibit C for identification.
Your Honor, and I just preserve my objection to the extent that Mr. Wong, or Chief Wong, just purported to provide opposing counsel a copy of the exhibit. However, clearly it's not a complete copy of the exhibit. A complete copy would include an exact copy of whatever is on that disc referenced in Exhibit 1.
And what is on the disc? There is a disc. Exhibit C is not an evidence, but it is a document with a disc. What is on the disc?
Additional documents.
And that was provided to Mr. Coughlin previously to today's date.
Via CD on July 2nd, 2013.
Okay, thank you. Your objection is noted, Mr. Coughlin. Go ahead, Mr. Moore.
Okay. Now I would like to do the same with the other evidence envelope that Mr. Turvey brought. I will fix.
This is from the manila envelope with case number 13-2445.
The record should reflect that I'm affixing the plaintiff's Exhibit F exhibit sticker to it. And again, Your Honor, I'd like a moment to compare it to the copy that I will provide to Mr. Coughlin today, which I had previously provided in discovery.
Okay.
And I'll just reference, Your Honor, note for the record that it appears in which the document Chief Wong just references, to which he would be providing a copy. And I'm going to go back on, I know you addressed this, but it is, it looks to be the document that the court's marshals made a copy of for Chief Wong. I realized the ameliorating effect of this court indicated would make me copies, but I just want that right. If it's possible at this time, if I may quickly just make a motion to be provided a copy of the audio of the last hearing in this trial, if possible, at the court's earliest convenience.
Yeah, we'll give you a copy of the recording.
Thank you, sir.
Thank you, Your Honor. The record should reflect that I have compared the plaintiff's Exhibit F with the copy of the document, or a copy of F that I had prepared for Mr. Coughlin. I'm sorry, Your Honor, may I just... And, Your Honor, I have found 3 pages in Plaintiff's Exhibit F that are not in the copy I made, and I believe he should receive a complete copy.
I agree.
So, if I could have these 3 pages copied for Mr. Coughlin and myself, I will put the documents back in F, adjust Mr. Coughlin's copy of F and my copy of F. And the record should reflect that I only brought 1 copy of F with me today, and that's why I asked your bailiff to make a second copy so that Mr. Coughlin would have a copy and I would have a copy.
Okay, that makes sense.
Your Honor, and I just object to that. I've had this court indicate to me on numerous instances that I had so much time to get this or that done, and I would submit that the same argument applies to Chief Wong hearing.
What you're objecting to essentially is that you're objecting to Mr. Wong giving you an incomplete copy of the exhibit he has for the court, and that doesn't make any sense at all. We're going to give you a complete copy of whatever exhibits he has that he plans to introduce in court, and that only makes common sense. I don't know why you object to that. Your objection is no rule.
All right, thank you for your indulgence, Your Honor. The record should reflect that I'm now handing to Mr. Coughlin an exact copy of Plaintiff's Exhibit F, to which the Plaintiff's Exhibit F sticker is attached. Exact copy, and I have that copy.
All right.
Officer Turby, with regard to the items that have been marked as Exhibit C and Exhibit F that you brought to court from evidence, Reno Police Department evidence today, where did you get the documents that were actually in those evidence envelopes?
From the State Bar of Nevada, Laura Peters.
Okay. And when you got them from her, what did you do with them?
Booked them in evidence.
And did you do the sealing on the envelopes yourself?
Yes, sir.
Okay, and then were the envelopes today sealed when you brought them to court?
Yes, sir.
And who opened the seal?
I did.
Today in court?
Yes, sir.
You know, no additional questions at this time.
All right, Mr. Coughlin, cross-examination of Detective Uterby.
Yes, sir. Good morning to Detective Uterby. You just referenced receiving, I believe it's Exhibit F from the State Bar of Nevada's Laura Peters.
Yes, sir.
What is your understanding of her position with the State Bar of Nevada?
Objection, relevance.
I'll overrule that. Go ahead and answer that question, Mr. Coughlin. That's a fair question. Go ahead.
She works there. I don't know what her exact position is.
Did she ever make any indication to you as to what her position was?
I believe she told me a title, but I don't recall what it was.
Do you remember her indicating that she was a paralegal and or investigator with the State Bar of Nevada?
No, sir.
Did she ever indicate to you that she was the clerk of court of the State Bar of Nevada?
No, sir.
When you say the State Bar of Nevada's Laura Peters provided you Exhibit F, is that correct? I believe the bar testified to that.
Yes, sir.
Did she make any indication as to what it was and why she was providing it to you?
She said it was a fax that she'd received at the office, or the office had received.
Is okay. She referenced the office.
In the State Bar of Nevada.
She didn't make any indication at the time that the State Bar Court had received a filing or anything in that regard?
Not that I recall.
So she characterized what she provided to you in Exhibit F as simply a fax received?
Yes, sir.
Did she indicate whom it was received from?
The title on it states that copy.
Did she indicate in any regard whom that person was and what connection he may have to the State Bar of Nevada and or why that person may have allegedly faxed something, Exhibit F or something like it, to the State Bar and or Ms. Peters?
They had handled proceedings with Zach Hoffman.
And what were you told in that regard?
Objection, relevance.
Yeah, how is that relevant, Mr. Coughlin?
In terms of what was
Additionally, it
relevant?
could be hearsay what Ms. Peters has to say, but how is it relevant to the limited information that Detective Uterby testified to today about receiving the evidence, booking the evidence, then opening the evidence? So how's that relevant?
And just to clarify, in terms of how's it relevant
Is
to
it
what was
relevant to
on
this
the
case?
direct?
Is it relevant to what Officer Detective Uterby testified to under direct examination?
Okay, so it's not just what was brought up on direct, but as to this case.
Tell me how it's relevant to the direct examination.
To the direct
Your cross-examination is limited to what Detective Uterby testified to on direct.
Okay. Well, it's related closely to the same subject matter with respect to Detective Uterby on direct reporting to identify a document in the Exhibit F. Granted, it seems as though it was extremely limited what he testified to on direct.
I think that would be a fair characterization that Detective Uterby's testifying was extremely limited.
Just to make sure, Your Honor, all I really noticed was
I just want you to tell me how it's so I can make a ruling. Mr. Wong has objected as to relevancy. You tell me how it's relevant to what he's testified to on. Why don't you do this? I'm going to sustain the objection and ask you to re-ask the question. Go ahead and ask another question.
okay.
Rephrase your question.
Okay. Detective Uterby, why did you book Why did you accept Exhibit F as evidence?
It was received as a violation of a restraining order.
How did you come to the determination that the state bar's, as you referenced, receiving Exhibit F was a violation of such order?
I reviewed the order that was told to me by Laura Peters that was in place, discovered that order had been filed and served, and noticed that there was supposed to be no facsimiles to the state bar by Zach Coughlin, hence being a violation of the restraining order.
Your understanding of the order was that it barred any and all facsimiles?
Yes.
Do you recall, in reviewing the order, language therein that bars contacting the state bar?
Not exactly.
Would you say the order barred the defendant from contacting the state bar by a facsimile?
Your Honor, objection, the order speaks for itself.
I'm going to overrule the objection. Let Officer Uterby testify with. Go ahead, Mr. Coughlin, ask that question.
Would you say the order barred the defendant from contacting the state bar via facsimile?
Yes.
And what's your understanding of what's included within the term of contacting?
That's irrelevant, and that does call for a legal conclusion. I'll make that determination as part of this case. I don't think any of us could offer opinions. I don't think Detective Uterby in this case with these facts is qualified to answer that question. That's a question of the law for the court.
Did the state bars, did you interact with anyone besides Ms. Peters at the state bar?
I believe I talked to Patrick Owen.
Patrick Owen King?
Yes.
On one occasion or more than one occasion?
I don't recall exactly.
Do you remember when you spoke with Mr. King?
Not the exact date and time.
Do you remember the substance of your communication with Mr. King?
It was about
relevance.
Well, how's that relevant? What Mr. King had to say to Detective Uterby related to what Detective Uterby has testified to on direct examination?
Detective Uterby, it's relevant to the extent that Detective Uterby testified as to what it is this item in Exhibit F was.
Agree.
So,
I don't think it's relevant. I'm going to sustain the objection. You can rephrase your question. Remember, Mr. Coughlin, Detective Uterby, we're giving you a lot of leeway here. Both Mr. Wong, through his lack of objections, might let you ask questions that possibly would be irrelevant, but try to keep your focus on what he's testified to today on direct examination. That's certainly a free source of cross-examination by you.
yes, sir. I understand it's probably my responsibility to remember, Your Honor, but to whatever extent the court can help me narrow, respond to your directive just then.
Okay. I think the answer to your inquiry, if that's a fair one, is that Detective Uterby, I made notes, testified that he brought evidence over from Reno PD from the evidence locker. The evidence from that locker is reflected in Exhibit C and F, which have been solely marked for identification and not have been offered for admission. He picked those up. Those are the same exhibits that he booked into evidence at the time he received both exhibits from the State Bar and Laura Peters. One of them was a fax, and the other note I have is one is a copy of something that was given to someone from you. That's all that's been testified to. He essentially picked up the evidence, booked it into evidence, brought it over to court, opened it up, and clarified that that's what the evidence he received back from Laura Peters from the State Bar.
Yes, sir. And then, with respect to the extent to which he opened the door to further inquiry and the subsequent incident to his testimony that Exhibit F was somehow a violation of the protection order, may I?
He did not open the door. You asked him if his opinion he thought it was a violation. He said yes. It's hardly the door being opened by Detective Uterby. That was a door that was opened by you. And in his opinion, he testified yes, but ultimately that's his opinion that is taken into consideration by the court. But I'll make any final decisions whether the conduct as alleged in the complaint is a violation of state law.
Yes, sir, Your Honor, but with respect to, I believe it's the Twombly case and the analysis of whether any bad faith or misconduct or vindictive motive is present in this case, incident to the arrest and the charge, I would submit that's relevant. It's relevant. Detective Turbidy's understanding of what would be a violation and understanding just what it is this Exhibit F is or was, I would submit is relevant to, particularly to the extent that the leeway afforded me by Chief Wong, resulting in Detective Turbidy's testimony that he believed a violation had occurred. And just to the extent it might lessen any extent to which I need to call Detective Turbidy in my own case in chief. If I may.
I've seen no evidence of any bad faith or any misconduct by any witness in this case. In any of the matters I've reviewed up to date, certainly none present in the trial. So the objection by Mr. Wong is sustained. You can ask another question.
Okay, just to make sure I don't go back and ask the
Mr.
same
Wong, just
question.
ask another question, and we'll deal with whether or not Mr. Wong feels your question is objectionable. He'll object, and we'll
Yes,
go
sir.
from there. So go ahead and ask another
Because
question.
I just can't remember what he objected to. Which question? I don't want to ask it again.
He objected to whether or not the question was whether or not Detective Turbidy had spoken with Patrick Owen King at the state bar. He said he had. He didn't recollect the date, and he wanted to go into the substance of those conversations. And I've sustained Mr. Wong's objection that that's irrelevant to and outside the scope of direct examination. So go ahead.
Okay, Your Honor, just
ask another question. We're not going to have a running diatribe for half an hour. I want you to ask him another question or cease questioning when you're done. One of the two.
yes, sir. Hopefully this isn't going back on your order.
Ask the question, Mr. Coughlin.
Detective Turbidy, did Miss Peters indicate what sort of, you referenced a proceeding earlier? Did she indicate what sort of proceeding the defendant had with the state bar?
No, sir.
What was your understanding of her use of the term proceeding, what she meant by that?
Business with the state bar.
Business, with the term proceeding being equivalent to business?
That individual's dealings with the state bar, I don't know the exact specifics.
Did you conduct any analysis of whether any such proceeding Ms. Peters referenced might involve some constitutionally protected right of the defendant to submit filings to a court within which he had a proceeding ongoing?
No, sir.
Is it your understanding that one would be barred from filing something in a court within which they have a proceeding? Should they be subject to this protection order?
Yeah, that's not a question that's proper for Officer Detective Turbidy to answer. It's also outside the scope of direct examination.
And I just submit that Bailiff Inglis testified as to legal concepts of service.
Their objection is sustained. Ask another question related to what Detective Turbidy has testified to.
Did Ms. Peters or anyone with the State Bar make any indication to you as to how the defendant may have properly submitted this Exhibit A that the defendant is purported to have submitted?
Objection. Calls for hearsay from Ms. Peters.
Coughlin?
Not going to prove truth in the matter asserted, but rather state of mind.
I think it's irrelevant, so the objection is sustained.
Would the defendant have been in violation of the order had he mailed an item such as Exhibit F through the U.S. mail to the State Bar?
Objection, Your Honor. I think Mr. Coughlin is again asking Detective Uturity for legal interpretation of the order. Your Honor has already indicated that you're going to make that determination.
That's true, and I tell you, Mr. Coughlin, I'm not sure you want Detective Uturity even answering that question. I'm not going to let him answer a question that goes to the ultimate question of law in this case, of whether or not that document was allowed or not. So I'm going to sustain that objection.
Yes, sir, Your Honor.
He's not in a position, Detective Uturity, notwithstanding his credentials, is not in a position to testify as to ultimate questions of law that will be determined by this court. So why don't we refocus your inquiry on what he's had to testify today, what he's testified here today, rather.
Yes, sir, Your Honor. Did you conduct any further investigation to determine whether or not Exhibit F was indeed sent by the defendant?
No, sir.
Is it fair to say that the sole basis upon which you made that other assumption or determination was provided by what you referenced as the fax header, indicating it was from the defendant?
That and the fax itself, sir.
That and the fact of what?
The fax. Sorry, sir.
The fax.
The facsimile.
When you say the fax itself, can you explain what you mean by that?
The content of it?
So you reviewed the content of it?
Yes, sir.
And how would you describe the content of it?
I'd have to review it. It was, I think, 70 pages or something. I don't remember all of it.
Your Honor, if I may approach to provide the witness the review views.
Well, I'm not going to allow that. Whether the content of a fax is irrelevant to whether or not a fax was even received. The content makes no difference in this matter, whether it was 1 or 70 pages. The Detective Uturity has essentially testified to a chain of custody. He picked up evidence, he delivered it for protocol to Reno PD, he picked it up for protocol, brought it back to court and had it marked. And that's the extent of your cross-examination related to that. You've asked enough questions and there may not be much more to ask that's relevant, which hasn't been asked already, Mr. Coughlin, so go ahead.
Yes, sir, and I'll conclude my cross in that respect.
Can you redirect?
No, Your Honor.
Detective Uturity, thank you. Remind you while this case is pending not to have any discussion with anybody related to this case until you're advised by the court, Mr. Wong or Mr. Coughlin, that your case is over. Okay?
Yes, sir.
Your Honor, can I just clarify that Detective Uturity is still subject to the subpoena and I can call him on my...
You can subpoena him if you want to subpoena him.
Well, I don't believe he's been released from his subpoena
I'm
now.
not going to release him. He's able to leave the court today. He's not going to have to stick around until a later time.
In that case, I would ask that I be permitted to continue my cross-examination. It's my understanding that where he's not released from the subpoena, I'm able to call him.
You can call him back later in this case if you decide to call him back. But he's done now. Thank you.
Your Honor, I would ask not any kind of a redirect question, but I just want to know what the protocol is, Officer Uturity, for the evidence envelopes. Do they need to go back to evidence?
No, they're going to stay here. They're going to stay here as part of the evidence and part of the chain of custody. So those will be kept in custody of the court till further notice. Those aren't for me to see because those go to Mr. Wong. All right.
Your Honor, I call Laura Peters.
Ms. Peters, good morning.
Good morning.
Have a seat. Remind you, you're under oath. Whenever you're ready, Mr. Wong.
Thank you, Your Honor. Ms. Peter, it's important that you speak loud and directly into the microphone because this is being audio recorded. Do you understand that?
Sure, yeah.
Would you please state your full name and spell your last name for the record?
Laura Peters, Peters.
What is your profession or occupation?
I'm a paralegal with the State Bar of Nevada,
How long have you had that occupation?
6.5 years.
Were you in that occupation on December 26, 2012?
Yes,
How about January 3rd, 2013?
yes,
How about January 17, 2013?
yes.
Where is your office?
At 9456 R Boulevard in South Meadows in Reno?
Is that the State Bar Nevada office in Reno?
Yes,
And is that location within the city of Reno?
yes,
Did you work on January 3rd, 2013?
yes.
Do you recall how long, when you ended your day that day?
Around 10 after 5, maybe 5:15.
Okay. Would you please tell the court very briefly what happened when you were ending work that day?
Okay. Paula, a coworker, and I were getting ready to leave, and Mr. Coughlin had been showing up at the office.
Sorry, objection, Your Honor, relevancy.
Mr. Wong.
Do you know the defendant, Zachary Coughlin?
I did.
How do you know?
I'm sorry. Your Honor, did you say overrule? I couldn't.
Mr. Wong apparently has withdrawn the question. He's going to rephrase the question, so your objection, Mr. Coughlin, at this point was sustained. So, Mr. Wong, re-ask it. Go ahead and re-ask the
Do
question.
you know the defendant, Zachary Coughlin?
Yes,
Do you see him in the courtroom here today?
yes.
Would you please point him out and describe the clothing he's wearing today?
Sitting over there in a suit and glasses with a green frame.
Director, note the identification, Mr. Coughlin.
Do you have personal knowledge as to whether or not the State Bar of Nevada had a disciplinary action with Mr. Coughlin in or about December 2012?
Yes,
Prior to January 3rd, 2013, did you have any contact with Mr. Coughlin?
I did.
Did you have any face-to-face contact with him?
I did.
Okay. So again, on January 3rd, 2013, at the end of your day, just very, very briefly, tell the court what you observed.
As Paula and I were getting ready to lock up for the night, a gentleman came towards us and had a stack of paper in his hands.
Was that gentleman Mr.
Objection,
Coughlin?
Your Honor, relevancy.
That's relevant, Mr. Coughlin. That's overruled.
Was that gentleman Mr. Coughlin?
No.
Let me show you what has been marked, but not yet admitted, marked as Appendix Exhibit C. Just please review that to yourself when you're done looking up. Ms. Peters, when the gentleman approached where exactly physically located were you?
We were approaching the front door to leave.
You were still inside at that point in time?
Yes.
Okay. What did you observe?
A man was walking towards us through the parking lot, and he was carrying what appeared to be this stack of paper, and I kind of identified it as being Zach's because of the CD on the back.
Okay. Now, did you go outside of the State Bar office?
Eventually, yeah,
Okay.
to go to my car.
What did you observe this gentleman to do?
He approached us and asked if he could file the document in, and
Let me ask you, were you inside the office or outside the office at
I
that
was
time?
inside the office.
Okay. Did he come into the door?
No,
Okay, so how could you hear him through the door?
we might have had the door open. There's a little mail flap, so
Okay. And then
probably
what
had it
happened?
cracked open. He asked if he could file the documents in, and I said, no, it's after hours, and we're getting ready to leave.
What happened next?
I said, if you want, you can put him through the mail slot, and that's what he did.
What happened after that?
He walked away and we locked the door and left.
What did you do specifically?
I believe I just went to my car.
What did you see upon getting into your car?
The man was walking towards a small Toyota or Nissan at the end of the driveway, or across the street is Sand Hill, and the car was parked right in front of there. It
What
wasn't
car?
on the property.
What car?
What I believe to be Zach's car,
Why do you believe it was Zach's car?
because I had seen it before on several occasions.
What happened next?
I just got in my car and drove away. I noticed that the man would continue to walk towards the car.
Objection, Your Honor, relevancy.
Mr. Wong?
It's just the circumstances of the case and what she observed, Your Honor, at this particular incident.
Overrule the objection.
So would you please look at Exhibit C? Do you recognize that document?
I do.
Okay. In the course of this particular case, did you provide any evidence to Officer Eternity of the Reno Police Department?
Yes,
Did you provide Exhibit C?
I did.
Were you working on January 17, 2013?
I was.
Do you recall? Let's set Exhibit C aside. Let me show you what's been marked and not yet admitted as Plaintiff's Exhibit F. Do you recognize that document?
I do.
Okay. Does the State Bar of Nevada have a fax machine?
Yes, we do.
Okay. On January 17, 2013, were you working?
I was.
Did you have an occasion to approach the fax machine?
I did.
And what did you observe, if anything, when you approached the fax machine?
This document was coming out and it was fairly lengthy.
What did you do?
I stopped the transmission.
Did you subsequently provide the document you said that was coming out of the fax machine to Officer Eternity?
I did.
And did you give him the exact document?
Yes.
Did you have a belief as to who those documents came from?
From the cover sheet, I kind of identified that they came from Zach.
Mr. Goffin, the defense?
Yes. Uh-huh.
Your Honor, I move for admission of cities C and F.
Mr. Kaufman, any objection to C? C being the packet that was placed in the State Bar mail slot on January 3rd, 2013.
Yes, Your Honor,
What's the
on
basis of your
multiple
objection?
bases.
What's that?
On a number of bases, the first being which I've not been provided a copy.
I'm sorry.
Time he ceased to introduce Exhibit C, and that the disc is missing from the back thereof.
Oh, yeah, I did give him a copy of Exhibit C. That was the 100-page document that I spent time reviewing from Exhibit C from Officer Eternity's evidence envelope, and I spent that time reviewing to make sure what I gave him.
So a copy was provided to Mr. Kaufman today.
And previously pursuant to discovery.
Your Honor,
What other objections do you have?
incident to Sierra Glass, Mr. Wong has a duty of candor to this tribunal 3.4 and to opposing counsel, where he's purporting that he provided a copy of a document, and he clearly has not provided a complete copy of that document. I would ask that this Exhibit C not be introduced, and that I'd be permitted to note for the record that the Sierra Glass case, wherein counsel purported to be reading from the deposition of a case and giving the impression that he was, I guess, reading it verbatim when he wasn't, and that was a violation of the rules of professional conduct.
All right. C is admitted into evidence. What about F, Mr. Kaufman? that would be a fax received by the state bar, as Ms. Peters has described the facts that she believed had been sent by you.
Your Honor, though I had an additional basis of objection to Exhibit C, that was just the initial, and then the additional one would be relevancy, to the extent
Well,
that...
isn't it clearly relevant?
I don't think so, not at
Well,
all.
I think it is, so your objection's
Well,
overruled.
can I be heard on that issue?
Make it brief, Mr. Coughlin, because your objections don't have much merit, so go ahead.
Well, if we're here today to determine whether or not a violation of protection order occurred.
That's why we're here.
Okay. If something is clearly protected activity, then it's not relevant.
No, we're not here to discuss the collateral order issued by the court. The court has issued, the Justice Court has issued a temporary protective order, and the Justice Court has issued an extended protective order. We're here today to decide if those orders were violated. Any collateral issues related to the sufficiency of those documents are not going to be discussed.
I don't believe that's collateral even, or it's both collateral and non-collateral to the extent that whether or not something's a violation entails a determination of what the document was. And
How can I determine what that document was if it's not in evidence?
well, I would submit that in order to be submitted into evidence, it needs to be material and relevant. And if it is clearly neither, to the extent that it appears to be a pleading on pleading paper with a caption in the State Bar Court of Nevada with case numbers and the State Bar of Nevada listed as a party therein, that under no circumstances would such be tantamount to a violation of the order, and in that respect it would not be relevant.
I think it's both material and relevant. Exhibit C is admitted. Would it give an objection to F?
If I could basically copy and paste those objections to F as well, Your Honor, just...
For a note for the record, Exhibit F is also admitted into evidence. So can I get copies of those? Go ahead, Mr. Wong.
And just quickly, though, Your Honor, to the extent that Exhibit F does not appear to be, it depends on what one views as a complete copy of a document. The bottom of Exhibit F indicates a number of pages, with the second page indicating one of a total number of pages, which clearly are not provided here.
I need those. I'd like to see those, please. Thank you. Go ahead, Mr. Kaufman.
So I believe Mr. Wong needs to provide a complete copy of the document. I guess that would entail analysis of what is included in the term document, but to the extent that this appears to be a filing of some 370 pages, and only, I believe, pages are somewhat out of order in my copy. Maybe these are the last three that Mr. Wong had pre-copied.
What is your objection, Mr. Kaufman? You're kind of rambling right now. It makes it kind of hard for the court to follow when you're, quite frankly, just up rambling. What is...
Not a complete copy of the
Okay.
document.
Mr. Wong, you want to respond to that?
Your Honor, again, I believe that the copy of F that I gave Mr. Kaufman is an exact copy of City's Exhibit F. As you recall, I attached the Plaintiff's Exhibit F sticker to the document that...
What you're saying is you've attached, that's the exhibit that you received. It may not be a complete copy, but that's what was put in evidence, correct?
Yes, and I made copies, so I believe what I did just give him and previously provided is an exact copy of Exhibit F. I believe.
F is admitted. Those objections go to the weight, not the admissibility of the exhibits, Mr. Kaufman. All right, Mr. Wong, go ahead.
Your Honor, I just want to show Peter's Exhibit C and F.
All right, there's C and there's F.
So, Ms. Peters, with regard to Exhibit C, the first page, in general, what is it?
It appears to be a motion for a new
Objection, Your Honor, calls for
disciplinary
conclusion.
hearing.
Are you, just wait. There's an objection by Mr. Coughlin, appears to be a legal conclusion. You asked what that document is. Are you reading from the document in terms of what it says?
Yes.
That's not a legal conclusion. She's just reading from what the document says. Go ahead.
Well, first of all, it appears to
Objection,
be,
Your Honor, relevancy.
Overruled.
it appears to be a document in what case? Can you give us the case name?
The State Bar versus Zachary Coughlin.
Okay. Could you please read into the record the title of the document?
Motion for new trial, motion to alter or amend Chair Echeverria's order of 12-14-12. Motion for reconsideration.
And directing your attention to the second to the last page, what date appears to be on that page?
January 3rd, 2012.
And whose signature does it appear to be?
Zach Coughlin.
Objection, Your Honor, calls for a legal conclusion or expert testimony, and there hasn't been any foundation provided with respect to Ms. Peters' extent. Ms. Peters.
What is your objection?
Ability.
I'm losing track when you start to ramble.
There needs foundation. There's
Relating to the signature?
yes.
I'll sustain that portion of your objection. I agree. Mr. Coughlin, she can testify what's on there, but unless there's some foundation laid that she is familiar with Mr. Coughlin's signature, I agree with Mr. Coughlin, she can't testify to that.
Well, the question was what it appeared to be, but I'll withdraw that question.
Okay, but the objection is not even sustained.
So, Ms. Peters, looking at Plaintiff's Exhibit F, admitted in evidence, looking to the second page of that document, does that appear to be a proceeding?
Yes,
In what case?
in the State Bar versus Zachary Coughlin.
Please read into
I'm
the
sorry
record.
to interject, but Your Honor, if I may just make a continuing objection to limit any my interruptions to the extent that Mr. Wong continues to appear to ask for a legal conclusion, wherein he's asking the witness to characterize what sort of documents in our filings are being admitted. And I believe when
I will sustain your objection. Mr. Wong can ask the witness to read what's contained in the exhibits, but I agree the witness can't offer any legal conclusion. So again, I sustain your objection, Mr. Coughlin.
Yeah, they're admitted in evidence. I have no further questions of Ms. Peters.
All right, can I get those from Ms. Peters? All right, Ms. Peters, Mr. Coughlin, cross-examine Ms. Peters.
yes, sir. Ms. Peters, what is your profession or occupation?
I'm the paralegal for the State Bar of Nevada.
Is it misleading for you to identify yourself simply as a paralegal with the State Bar of Nevada?
I don't think so.
Have you ever identified yourself in any other respect in connection with your employment with the State Bar of Nevada?
I really don't. I have different job duties.
Have you ever held yourself out as a clerk of court?
That's one of my job duties. I wouldn't say I hold myself out as one.
You wouldn't say you hold yourself out as one?
Well, I don't identify myself as one. That's part of my job duty,
Have you ever identified yourself as a clerk of court?
not to my knowledge.
Have you ever identified yourself as a clerk of court to the defendant?
No, not that I don't believe so.
Did you identify?
You've referred to me as the clerk of court, and I've asked you not to because it annoys me.
I'll remind you, you're under oath here, Clerk
Okay.
Peters.
Sure.
Did you, on September 9th at approximately 4:47 p.m., in a telephone conversation with the defendant, indicate that you were a clerk of court?
What year?
2013, 12.
I may have, just to describe my job duty.
How so?
Objection to relevance.
Your,
Mr. Coughlin, what is the relevance to this line of questioning?
Your Honor, I believe it goes to the, quote, circumstances of the case and what she observed and that it goes to the weight of the evidence and not the admissibility.
How does any conversation in September 2012 relate to either the conduct in this case, which is alleged in the complaints on January 3rd or January 17th? How is that relevant?
Well, in her testimony on direct, Clerk Peters was asked what her professional occupation is, and a description of her employment with the State Bar of Nevada. So initially, to whatever extent it was relevant, when Chief Wong was asking it, I'd submit that
I'll allow you to ask the question. Go ahead. Go ahead and rephrase the question, and Ms. Peters, you can answer that question to the best of your ability to answer that question. Go ahead, Mr. Kaufman. You can re-ask the
I
question.
don't entirely remember what the question was.
I believe the question stemmed from what I don't have it written down. It's the conversation on September 9th, 2012.
Yes.
What she had told you related to her profession.
Okay. Actually, on September 11th, 2012, what did you communicate to the defendant with respect to your being a clerk of court?
I'm not really sure that I recall the conversation.
Were you intoxicated during that phone call?
Of course not.
Had you had anything to drink that day?
Of course not. I was at work.
Had you gone to lunch that day?
Objection, relevance.
Now we're getting way outside the field of relevance, so I'm going to sustain that objection.
So is it fair to say your earlier testimony is no, you did not ever hold yourself out as a court clerk, and then subsequently you contradicted yourself and said, I may have indicated I was a court clerk to the defendant?
Your Honor, objection. I believe that's an incorrect characterization of her prior testimony.
I agree. It's not a correct characterization. You can ask some questions on cross-examination, Mr. Kaufman. I'm going to give you some leeway, but that is an incorrect characterization. I agree with the city attorney.
I didn't make a characterization. I asked a
Re-ask
question.
the question. I'm not going to have an argument with you. Re-ask the question. Rephrase your question.
Was your testimony inconsistent today with respect to your earlier indications as to whether or not you both have ever held yourself out as a court clerk or the clerk of court of the State Bar of Nevada, and your subsequent testimony as to what you may have told the defendant?
Your Honor, objection. It's a confusing question. It's very
It's a
long.
compound question.
And
You can ask questions, leading questions or direct questions, but it's a compound question. I don't understand it. I'm going to sustain the objection.
Okay. Did you earlier today testify that you have not held yourself out as a court clerk or the clerk of court of the State Bar of Nevada in the past?
That's a question you can answer if you can, Ms. Peters.
Court clerk is one of my job descriptions, one of my job duties, but I don't identify myself as that, no.
Okay. The objection, Your Honor, non-responsive. The question entailed.
Now, that was a responsive question. You may not like the answer you got, but you asked the question, she responded to it. Now, ask your next question.
Well, Your Honor, the question was whether she held herself out, and she testified as to what she identifies herself
Another
as.
question, Mr. Kaufman.
What do you mean by the term identify? Is that, are you using that term with respect to what you communicate to others, or how you feel about yourself?
When I show up for work every day, I'm a paralegal for the State Bar of Nevada. One of my job duties is to be the clerk of the court for the State Bar of Nevada. It's not something I perform 8 hours a day. I may not even do it on certain days.
Objection, Your Honor, non-responsive. I asked her.
No, I'm not going to have an argument with you. You asked the question, you got a response. You can ask questions on leading questions if you want, Mr. Kaufman, on cross, which certainly you have the right and probably the obligation to do. But you asked a question. I think it was a responsive question to exactly what you asked. So your objection is overruled.
Okay. What do you mean by identify?
If somebody were to walk up and ask me what I do for a living, I would say I'm a paralegal for the State Bar of Nevada. That's my identification.
During the communication with the defendant in September of 2012, did you indicate something to the effect that you were the clerk of court or the court clerk for the State Bar of Nevada, and that a default would not be taken against a respondent in a disciplinary matter absent several steps being taken, which you identified at that point?
Objection or relevance.
I don't understand the question. Rephrase the question. If I don't understand it, I don't know how the witness can understand it, so rephrase it.
Ms. Peters, in your interactions with the defendant in September to October of 2012, did you identify yourself as the clerk of court of the State Bar of Nevada and the court clerk and indicate that that being the case?
Mr. Coughlin, that's a compound question right off the bat. You can stop your question at some point and ask them, but you're asking compound questions and call for 3 or 4 responses. So your first part of the question was in September and October. Did Ms. Peters identify herself to you as the court clerk? If that's a question you can answer, if you remember.
I believe I did, to the extent that I was describing one of my job duties.
Next question.
And what, to the best of your memory, did you say in that regard?
I probably said I act as the clerk of the court for the State Bar and I file in documents. But I can't be sure because I don't recall the conversation exactly.
Did you identify yourself as the court clerk in addition to as the clerk of court?
I don't believe I would do that.
Is there a difference in your opinion between a court clerk and a clerk
I
of
don't
court?
really understand your question.
You want to rephrase the question?
In your opinion, is there a difference between one being a court clerk and the clerk of court?
I guess not.
Have you been told that you are either a court clerk or the clerk of court by anyone connected with the State Bar?
Your Honor, objection. This whole line of questioning is irrelevant.
It's getting to be irrelevant, so I'm going to sustain the question. It's not at all relevant in my ultimate determination, so that objection is sustained.
If
It's been asked and answered, and it's sustained. Move on to another series and another line of questions.
Okay. Did you, during this time period in question, at any point, actually, in your interactions with the defendant, particularly in the disciplinary proceeding context, did you indicate something to the effect that a default would not be taken against the defendant absent certain steps and or occurrences happening?
I don't believe I did. That's a procedural situation, and I don't make the call if the default gets taken or not. And it actually didn't happen.
Did you communicate anything to the defendant with respect to, regardless of whether you make the call, anything with respect to what need occur before a default would be taken?
Your Honor, objection, relevance.
How's the relevance to this case, whether or not there was a violation of the EPO or the TPO? How's that relevant?
Your Honor, I believe it's relevant to the extent that Clerk of Court Peters has clearly held herself out as such, a clerk of court and both a court clerk, and that at that time she made express indication that her status as the clerk of court of the State Bar of Nevada ensured that it was her call that a default would not be taken absent another round of certified mailing of the SCR 105 complaint taking place, and whereupon the failure to attain a signature card in connection therewith wouldn't necessarily need to result in a notice of intent of default taken out, and that it was Clerk of Court Peters' guarantee.
Tell me how that's relevant. to the two criminal complaints on file with this court?
It's relevant in that and this is not a collateral attack, NRS
Say
33.
it was, I'm just asking you to tell me how it's relevant, because I said I'm not seeing a nexus.
NRS 33.360 provides that protection orders do not and cannot impede any constitutional right one has, such as the ability to access courts, their First Amendment right, their substantive and procedural due process rights to protect something like a 14th Amendment protected law license, which has been declared property right by the United States Supreme Court under the 14th Amendment. In that respect, where Clerk of Court Peters has continually held herself out as the Clerk of Court, and where Assistant Bar Counsel King has continually referred to her as both the Court Clerk and the Clerk of Court.
You did not answer my question.
Well, yeah,
It's
it's just-
how is it relevant? Just tell me how it's relevant. You can tell me that in 30 words or less.
If these are filings, they're not included within the purview of contacting. They're absolutely protected activity. It's a lawful act.
And that is a question ultimately for the court to decide, not for Ms. Peters to decide. So your objection is sustained. Move on to your next question.
Yes, Your Honor, but I believe...
I want you to ask your next question, or else we're going to sit here and have a diatribe going on for minutes that serves nobody any purpose. Ask your next question.
I understand, Your Honor. With respect to the Twombly case and any misconduct that might be revealed herein on your part, Ms. Peters, have you obscured your functioning and being held out in the capacity of and being held out as the Clerk of Court to the Reno Police Department?
Objection argumentative.
I'm going to overrule it. Go ahead and answer that question if you can answer it.
Okay. Well, I have never represented one way or the other what my job is with the Reno Police Department, for one thing. And I don't really understand your reference to Twombly. I don't get that.
So then you can't answer the question because you don't understand it, correct?
Correct.
Did you ever tell the Reno Police Department that you were the paralegal or investigator or both the State Bar of Nevada?
I don't believe I did.
Is it possible that you did?
I suppose it's possible.
Why do you use the term believe? Is that meant to indicate some lack of certainty?
I don't know, it's just a word. I don't specifically recall identifying myself as anything to the Reno Police Department. I've never had the need to do that.
Did you feel it would be relevant to indicate to the Reno Police Department that you were the Clerk of Court of the State Bar of Nevada and or Court Clerk?
No,
Why is that?
I would have no reason to.
Because
Because why would the Reno Police Department care what I do for a living?
did you ever consider that your being a court clerk, and Your Honor, I've asked that, and or court clerk, clerk of court of the State Bar of Nevada, and you're receiving filings and or other documents therein may involve a respondent engaging in a...
I mean, listen, that question already is a compound question, and you begin to ramble on your questions. If you want to ask Ms. Peters questions, you can ask her a question, but you begin to engage in a rambling narrative that is not a question, it's very difficult for the court to follow, and you're here to ask her some questions, so rephrase your question.
Yes, sir. Is it your understanding that it would be a violation of the protection order, the temporary protection order in this case, for the defendant to have mailed you Exhibit F, or C rather?
That's a question this witness can't answer. I believe Mr. Wong is being very generous. I'm not objecting, but I can tell you that calls for the same legal conclusion you tried to elicit from Detective Uturby. Ms. Peters is not in a position to testify as to whether or not, in her opinion, certain documents received by the bar are in violation of the restraining order that's been issued against you. So that you're not allowed to ask those type of questions. I don't know. She's not to answer that question. She's not in a position to do that. I also don't think you want to get the answers she may give you, Mr. Coughlin. So to a certain degree, I'm objecting to protect the record from yourself.
I object to that.
All right, go ahead. Next question.
I do not believe the court is
Next
just
question.
on my case for me.
Next question.
Just to state for the record that I believe that goes to the circumstances of the case and what she observed and the way.
Next question, Mr. Coughlin. I've overruled it now.
Yes, sir.
Indicate you're not going to go down that road. Ask the next question.
Clerk of Court Peters, what is Exhibit C?
We did provide a copy to Ms. Peters of Exhibit C.
It's the stack of paperwork that a gentleman was attempting to deliver to our office on January 3rd at about 10 after 5.
How, are you sure it was after 5 p.m.?
Yes, I was getting ready to leave, and I do clock out, so I know it was after 5.
Do you have any sort of, what's entailed in your clocking out?
I clock out using our computer system.
So would there be a record of that?
I suppose there would be.
Does that entail, it doesn't entail punching a card into something?
No.
Swiping
It's
a key
done
fob?
computerized.
Okay. And you're sure it was after 5 p.m.?
Yes, I don't leave before 5.
Ever?
I have on occasion when I have permission to do so, but no, on that particular day, no. It was after 5.
Okay. If someone wishes to file a document in a disciplinary matter with the State Bar of Nevada, how would they do so?
Your Honor, I'm going to base an objection on relevance. What's relevant is not what other people may do, but what actually happened in this case.
How's that relevant, Mr. Coughlin? You can answer the question in 30 seconds or less. How's that relevant?
Well, one must, under Nevada law, or NRS 33.360, be permitted to engage in constitutionally protected activities such as filing documents in cases in courts in which they are a party, or their First Amendment or 14th Amendment rights. I'm asking Clerk of Court Peters how that might be done.
Right, fair enough. You can answer that question. How do parties file documents with the State Bar?
Usually they'll walk in during business hours, and I'll go and get my stamp and stamp the file and give them back a copy if they provide me one.
Does your stamp identify you as a court clerk or clerk of court?
Not me personally, no. I sign my name on the line underneath the file stamp.
And why do you sign your name?
I don't know, because there's a line there to sign it. And that's what other court clerks do.
And do you do that because you're a court clerk?
That is one of my job responsibilities, yes.
Okay. On September 25th, when the defendant came to
September 25th of what year?
I'm sorry, 2012.
Thank you.
When the defendant came to the State Bar's offices for a hearing, did Assistant Bar Counsel King attempt to serve the defendant a copy of the complaint in his disciplinary proceeding?
Objection relevant.
That's not relevant. Sustained.
If I may make an offer of proof.
Go ahead. Make it short, though, Mr. Coughlin. You're starting to engage in kind of a waste of time through these series of irrelevant questions and long diatribes. We're trying to give you some leeway to go ahead.
At that time, Assistant Bar Counsel King attempted to serve the defendant a copy of the complaint in his disciplinary proceeding, and then upon Mr. King being informed that a party generally can't serve complaint, Mr. King indicated that he gave the complaint to Ms. Peters and said something to the effect of that he was having Clerk of Court Peters serve the defendant a copy of the complaint, and that she was not, quote, not a party.
I was just telling you what's relevant. You lose me. I don't know how many times I've got to mention to you, you begin to engage in a diatribe, but I think you're just talking to talk. What is the relevance of the conversation or the conduct of the state bar proceeding in September 2012 to the case here today?
Well, it goes to both Mr. King, State Bar, and Clerk Peters holding herself out as the clerk of court and the court clerk of the State Bar of Nevada, and where the allegations.
Just tell me how it's relevant. I don't want to hear you go off in a 5-minute diatribe. I think I've said this numerous times. Just tell me how it's relevant.
The allegations here and relate to what Clerk of Court Peters herself is characterized as filings in a disciplinary proceeding.
All right, that objection is sustained. Next question, Mr. Coughlin.
Was there an objection? I don't even think there was an objection. It was
There was an
spontaneous.
objection that was irrelevant. We're asking you to move on to your next question. Go ahead. But Ms. Peters essentially has testified to, she received some documents, she's testified about what she does at the bar office. I think we beat that to death. We understand she's a clerk of the court or a court clerk. She received some paperwork in conjunction with her job at the court.
Your Honor, my question didn't go to whether or not she identifies as a
Why don't you
clerk of
ask your
court.
next question? I want you to ask your next question. That's your ask
Well,
your question.
I wish to ask a question that the court wants.
I don't know what questions you're going to ask. Ask your next question, and if Mr. Long objects,
I
he
understand,
objects.
Your Honor, but
Go
I
ahead.
spent 8 days in jail because judges in this court have said I didn't respond to their objection.
Ask the next question.
I understand,
Ask
Your
the
Honor.
next question, please.
Well, I'm unsure of whether I can or not.
Well, then don't ask any questions.
Now
Yeah.
I feel
Ask a
I'm
question.
frightened, and I feel an abuse of the contempt power is coercing me out of asking
No,
questions.
you're, as usual, Mr. Coughlin, your arguments are meritless. Ask your next question. You're not in any danger of anything. I'm just asking you to ask
I
relevant
object to that
questions.
characterization.
Ask your next question.
And I move for a mistrial incident.
Your mistrial tonight, ask for your next
Presiding
question.
judge making characterizations of my credibility.
Ask your next question.
Yes, Your Honor. Did Pat King refer to you as the clerk of court and or the court clerk in front of the defendant, Mr. Coughlin?
Objection relevant.
Sustained.
Okay.
It's irrelevant as to what, I will tell you that, Mr. Coughlin, it's irrelevant to the court whether or not whatever conversations that were mentioned to you by any parties related to Ms. Peters' job. She's already testified numerous times that she's the clerk. And one of her functions is she's the clerk of the court or the court clerk at the state bar.
And Your Honor, my
Let's
question.
move on to some new questions related to her direct examination.
My question, Your Honor, didn't go to what she identified herself as, what she held herself out to others.
That's your next question, please.
Did you tell Detective Uturbity or anyone with the Reno Police Department that you saw the defendant, Mr. Coughlin, at any time on January 3rd, 2013?
I did
Well,
not.
what's the dates again, Mr. Coughlin?
1/3/13, Your Honor.
13, okay, thank you.
I told him that I did not see you personally. I saw the gentleman walk up to the door, and then after he conducted his business and walked away, he was walking towards a car that looked a lot like yours.
In your testimony the following day at the 1/4/13 extension hearing in the Reno Justice Court case RCP 2012-00607, did you testify under oath to Chief Judge Pearson that you personally witnessed Mr. Coughlin in the vehicle?
You were too far away, I couldn't see you, so I don't think I would have testified if I saw you personally.
Did Mr. King ask you during that January 4th, 2013 extension hearing, in the case I'll refer to as 607, whether or not you personally witnessed Mr. Coughlin in the car or anywhere near the state bar at that time?
Mr. King wasn't questioning me at that hearing.
Did you testify at that hearing?
I think I did, but
Okay, I
Not
think you
Mr.
did.
King.
That's asked and answered. Next question.
You think you did? Were you there?
yes, of course I was there.
Did you take an oath?
Yes, I took an oath. Judge Pearson swore us in, and I believe we testified at our little table.
Did you testify in response to questions posed to you by Mr. King?
Mr. King wasn't asking me questions.
Was anybody?
Honestly, I don't recall the exact situation.
Had you had anything to drink or any drugs that morning?
Of course not. It was 8 in the morning.
So is it your testimony that you're not sure if you testified, but you might have?
Judge Pearson questioned us, both Pat and I, at the hearing for the extended order. As far as I recall, that was a year ago almost.
Is it your testimony that Mr. King did not ask you any questions at that
I'm
hearing?
going to listen. You've asked and answered that 3 times. She's testified that Mr. King did not ask her a question. I'm not sure if you heard that, but the answer is that he did not ask any questions. So that's been asked and answered.
Yes, sir. Did you ever write in a police report or any statement provided to the Reno Police Department that you personally witnessed Mr. Coughlin either in his vehicle or anywhere near the state bar on January 3rd, 2013 in connection with this situation you testified to with this unidentified man submitting a file?
I don't believe I identified you personally because I couldn't see you, and I'm not in the habit of lying statements. But it was your car, or it looked oddly like your car, and it was a gentleman walking towards me that had paperwork that was put together in the fashion that you usually put together your documents. So that led me to believe that it was your car, yes.
Did you see the gentleman enter the car?
I can't remember.
Did you tell anyone
He
you
was
did?
walking towards it. Huh?
Did you tell anyone that you saw the gentleman get into the vehicle? That you reference as one you believe belonged to Mr. Coughlin?
I'm not sure. He was walking toward the
No
front
question.
classes.
Right now, thank you. Let me respond to Mr. Coughlin's questions. Thank you.
Did the man you identified as submitting a filing on January 13th, or January 3rd, 2013, identify himself in any way?
I don't believe so.
Did he identify whether he was an agent of someone, a courier, or an employee, or something in that regard?
I don't believe so.
If you had received Exhibit C in the mail, would you have reported that to the police?
Objection relevance is not what happened.
I'm going to sustain, overrule that. Go ahead and ask that question.
Probably so. Yes. If I had received it in that manner, yes.
Is there any manner in which you could have received it that would not have resulted in your reporting it to the police?
If I had received it by mail, which is the way that normally people would bring things to the State Bar's attention, either that or walking in. But you were asked, because of your conduct, not to approach the state bar. You also had nothing pending before us. Everything had been sent to the Supreme Court by then.
Did you just testify that you would have reported to the police a violation of the protection order if Coughlin had mailed
Oh, I'm
Exhibit
sorry,
C
no,
to you?
I wouldn't have reported it had it been received by mail as you were told to do.
Did you testify to that approximately 90 seconds ago?
No, the record speaks for itself.
Yes, she's asked and answered that 2 times, Mr. Coughlin.
What did you mean 90 seconds ago when you testified?
Mr. Coughlin, she's asked and answered that question. Ask another question.
As to what she meant when she testified?
I'm not going to tell you what questions. That question's been asked and answered. Ask another question.
You referenced the defendant as having been asked not to file documents in what you earlier testified to as being a normal manner, i.e. walking in and having a stamp.
Yes. We had asked that you not appear at the state bar office, 1, because you're difficult to deal with, 2, because you show up after hours. And that makes it uncomfortable for people that are left in the building, including myself.
Why is that?
You have a manner of conversing with people that is never ending.
Do you converse with individuals outside of business hours?
I'm going to object to that. That's irrelevant. Ask some relevant questions.
just
Please.
testified.
Ask some relevant questions, please. That's irrelevant.
She just testified to me.
It's sustained. Ask another
Well,
question.
then I'd ask that it be stricken from the record.
Ask another question.
So, to clarify, is it your position that it would not have been a violation of the order had Coughlin mailed Exhibit C to you or the State Bar?
That's asked and answered.
It was answered 2 different ways.
It's asked and answered. Next question,
Well,
Mr.
I'm
Coughlin.
following
Next
up on
question.
your
Next
contradiction.
question, please. Next question. It's been asked and answered 2 or 3 times.
Okay.
You don't get to ask the witnesses the same question 3 or 4 times.
Then
Next
they can
question.
never
Next question,
repeat
please.
themselves or contradict themselves.
Next question, please, Mr. Coughlin.
Did you consider it a violation of the temporary protection order for the unidentified man you referred to earlier having, as you said, dropped a filing in the mail slot?
That's a question that calls for a legal conclusion that the court will determine this witness is not in a position to make that determination.
And I'm not asking it for the purpose of the legal conclusion, but rather
Or
the circumstances of
Move
the
on to
case
your next
and
question.
what she observed. I believe it's relevant to the extent that it goes
Next
to
question,
the
Mr.
analysis
Kaufman.
for bad faith conduct.
Next question.
Yes, sir. Court's indulgence for a minute.
Go ahead. Mr. Coughlin, as we get to the noon hour, how much more time do you anticipate you'll be spending on cross-examination?
It could be substantial.
Well, no, it's not going to be substantial, Mr. Coughlin, because you asked, her testimony hasn't been substantial, nor will your cross-examination. It's going to be limited to relevant evidence. So it will not be substantial, I'll tell you that right now. Give me an idea of how much longer.
Well, Your Honor, I would like to impeach her with the police reports and the transcripts of her testimony at the
Go
extension
ahead.
hearing.
Go ahead. You're allowed to impeach her any way you want to. Go ahead.
Okay. And just ask for the same level of indulgence. The court
You're going to
provided
get the
Mr.
same.
Wong
You're going to
waited
get the
10 minutes
same
for
level of.
copies.
you have it. Please review your documents. I'm giving it to you.
Your Honor.
In fact, this would be a good time to take our noon break, and then we'll resume cross-examination. That gives you time over the noon hour to review whatever documents you need to review. It's noon. We'll take our lunch hour. Ms. Peters, I remind you that you're in the middle of cross-examination. You're subject to the rule of exclusion. You're not to discuss your testimony with anybody except the parties. We'll reconvene here at 1 o'clock exactly, and that for trial you can pick up on your cross-examination. We'll be in recess.
Your Honor, would the court be secure so I can leave?
Yeah, we'll lock it all up, make sure it's secure. No one's convening anything in the court without both Mr. Coughlin and Mr. Long present.